examination.
So how,
Or to take
What
up
to
the
do?
matter day after tomorrow.
day after tomorrow, you know the problem.
Then Monday, my lord.
On the 21st, let us try.
21st, my lord.
Let us try. Yes. Give the
My
memo.
associate will file.
Page number 1, item 1 to 6. Page number 2, item 7 to 20.
Item 11.
Yes, 11. Withdraw. Give the memo. Yes.
Page 3, item 21 to 33.
Item 22, sub item 2, that is not related with the first item. Inadvertently, that has been tagged with.
Item?
Item 22, my item is sub item 1, sub item 2, that is KRLMC 1811. That is not related with the sub item 1.
I don't know why it is.
That is inadvertently tagged with.
Somebody might have informed the court, otherwise, why it is? Is there any order?
The first item is 376 case and it is 498.
In the first item, there is an order. The tag along with 18.
Anything may be wrongly mentioned.
Let
For
us
that
see, let
reason.
it come.
Yes.
Item 25, my lord, 25. Let it come after vacation, my lord.
21 minutes. 24. Withdraw, give the memo.
25 kindly adjourn, my lord, adjourn. After vacation.
We are going.
Sorry.
Page wise
Item 22. My lord, the matter has been settled between the parties. And the conductor matter is no way connected matter. is
And
what-
on your statement only it is tagged. Why have you given that statement then? I have recorded your statement and tagged the matter. And that's what he says, that it has nothing to do with this matter. Retake or this.
My lord,
Item 22, the other matter, 1811/2023 is retake.
and I may pardon, matter has been settled. Party will come from Barampur. In the meantime, the victim girl has born with a child. And the victim
What do you want, you tell me?
day after tomorrow, Friday. Friday, party will come from Barampur.
Yes.
Friday.
My lord, item 26, your lord.
Yes,
I'm praying for an adjournment, your lord.
yes, Arjan. Next.
After vacation.
Yes.
Page
Generally
4,
after vacation only. Yes.
page 4, item 34 to 45. Page 5, item 46 to 54.
My lord, item 52.
52. Yes.
I seek to file a further affidavit by
Then
Let it
counsel
come.
petitioner seeks to file further affidavit. Urgent. Yes.
obliged.
Page 6, item 55 to 69.
Withdraw. Yes. Give the memo. Yes.
Page 7, item 70 to 78. Page 8, item 79 to 91.
Item 79, I have a small prayer because today I'm little inconvenienced. It can be taken up tomorrow. Because I have a small function at my place. So I had to come only for that.
Tomorrow you know what will happen.
No, my lord, whatever.
Let it come after vacation.
No, my lord, it's an urgent matter. That's why it has been mentioned and brought before your lordships.
You
Today-
mentioned, got it
No,
listed
no,
now.
my
you
lord.
are-
Actually, I had told him for Thursday, but unfortunately,
See, we have to adjust our.
I
that's the
understand.
problem.
Lordship, if subject to your lordship's convenience.
I don't think it will reach tomorrow. If it listed, then tomorrow at the end of the board.
End of the board.
Item 82
Obliged.
after vacation.
After vacation 80.
Item number 80, my lord. I pray for an adjournment.
80, 82. Urgent. Yes.
Item 84. Item 84, there is a defect for removal of defect time be granted.
Mhm.
There is a defect for removal of defect time be granted. 84.
Defect to be cured. Yes.
Page 9, item 92 to 105.
Let's say item number 94. Some defects are there. I will remove the defect within 1 day.
You want to cure the defect?
Yes.
Yes.
104, my lord. Kindly answer.
94 is also cured to be.
94, no.
104.
104 years.
Adjournment.
Urgent. Yes.
94.
94.
103 also.
Huh?
103.
103. What do you want? Urgent.
That's
Urgent. 100. Yes. Yes.
Page 10, item 106 to 115. 111, my lord. Matter has been outcome settled. I have already filed the affidavit with Hinama. That has not been tagged with. Friday also, the party will come here.
See, the problem is, the court can't wait for the parties to come.
No, no, you're not.
At your own convenience, you will come. You have to see the convenience of the court also.
Any day. Kali ho ki por din ho, jo din ho rakhi hai.
Huh?
21st.
21st of all. Why can't they come today?
Madam?
Why they can't come today?
Affidavit আসেনি আমি কইলে তাদের ট্যাগ হয়নি
You only see your convenience. You don't see the convenience of anyone.
পার্টি আসছেন কিন্তু affidavit আসেনি
Anyway, keep it. Yes.
Page 11. Item 116
21st, madam.
to 120.
May I be pleased to make a mention, my lords? I am appearing on VC, my lord.
Wait, after the physical mentioning.
116 to 123. Page 12, item 124 to 131.
127
Sorry,
after vacation
which one?
127
1 to 27. Okay.
My lord, 130. So let it be after vacation or interim order to continue.
Who is from the other side?
Other side is the of India, that's taxation matter, your lordship, that deleted return of filing of the returns, so therefore the
Okay,
procedure.
urgent.
Interim order to continue.
Interim order to continue. 130.
130. Smile.
Page 13, item 132 to 140.
I'm trying for an adjournment.
Yes, urgent.
After vacation, your lordship, interim order with that.
Interim order.
My lord, item 138, my lord, I am appealing for the OP number 2, my lord. I have not filed the counter, my lord. Only taken after vacation.
To continue, my lord. My lord, interim order to continue. Yes.
138, huh?
Yes.
130.
My lord,
And counsel for the opposite party seeks time to file the counter. 1 week time is granted. to file
But
counter.
for mention, my lord.
Yes.
My lord, item number 139. On last occasion, my lord, direction for CRLMC 13567 of 2019 call for from the record because it was disposed of on the 482 ground. My lord, I obtained instruction from my client that there is nothing any filed by them CRLMC before.
What do you want?
My lord, I filed affidavit in this regard that there is nothing any previous petition filed by them.
Yes, what do you
And-
want? You tell me now.
To file affidavit and along with the leave of the court to present the party before this honorable court, my lord.
You bring them
My lord, after vacation, my lord.
after vacation.
my lord, 133 paper.
My lord,
After-
date may kindly be fixed.
Yes, yes, date will be.
Interim order.
Fix a date, huh?
Okay.
Yes.
139
My lord.
date.
Give it.
133 my lord, after.
Yes.
137, my lord, permitted to withdraw.
Give the memo. 137. Yes.
my lord item 15 not traced my lord
Huh?
in process already
In
item 15
15, 15.
15
15.
in process
In fact. Yes. Yes.
My lord, item 25. I prefer adjournment.
20.
After vacation.
Which one?
Item 20.
20 or 23?
20.
20. Urgent. Yes.
Pardon that. I pardon, my lord. One matter
Milord.
that CLMC 1545 of 2024. You'll also remember that recall of that PW1, that victim. That you'll also
I don't remember.
yes, you'll also pleased to dispose of the same, but order is not uploaded and connected with another
Today,
file
today it will be done.
and not connected with the 1545 of 2024.
Right now, no? 15?
45 of 2000. It disposed of on
Today,
8 4
today it will be done.
as well.
Yes.
No, it is connected with another file. Order sheet is CLMC.
May I be pardoned to make a mention, my lords? I am appearing
Item
on
9.
VC, my lord.
Item 9 kindly be adjourned.
19.
9.
9. Urgent. Yes.
Obligation.
Yes.
My lords.
Yes.
My lords,
Mr. Yeah, yes.
my lords, CRLMC number 1376 of 2024, my lords, were pleased to issue notice and grant stay, my lords. But inadvertently or unfortunately, my lords, the IE has not been part of portion of the IE has not been reflected in the order, my lords. May kindly bring it up, my lords, tomorrow or day after as per convenience of the court, my
So
lords.
the
Only
interim order was not continued.
It was granted, my lords, the first posting of the hearing, my lords. Interim stay was granted, but the same has not been reflected in the order, my lords. CRMC number 1376 of 2024.
I'll just check it up and then release it. वो दिखा दो मुझे. 13?
1376 of 24, my lords.
1376 of 24. I'll just check it up and yes.
My lords.
Show me the file.
Okay.
Yes.
Let's say item 128.
128.
Adjournment.
Urgent. Yes. Yes.
Item one.
Item.
Prevention.
Item. What is it? Yes. Why this is not coming?
Yesterday, my lord,
Yesterday you also made
somebody
it.
mentioned on that.
Yes.
To deliver the judgment, that is why.
I'm recusing.
My lord, I'm extremely sorry, Your Lordship. Unconditional apology, Your Lordship.
Apology will not do, sir. The letter have you seen? Read para 3 of the letter.
Your Lordship, I have seen it.
Read it loudly
I'm
for
sorry, my
the
lord.
benefit of the bar.
My lords, it's like dictating.
How dare your client, maybe overseas client, doesn't
Lordship.
mean that he'll write letter to the court and dictate the court saying that you pass a judgment tomorrow, today or
No, Your
tomorrow.
Lordship, it's my fault, Your Lordship. It should not have never been filed, my lord.
No fault. You have to set the standard high. Show me the letter.
Letter ta diyon.
Show me the letter.
Letter ta diyon.
Where is that?
Record.
Ask.
Bahar kari diyo, bahar kari diyo.
Ask it.
Ye jab se bahar kari diyo.
Copy there, right?
Data file kar diyo.
See, what is the so pressing urgency?
Your
You have
Lordship,
spent about 5 hours in your
Your
case.
Lordship, unconditional.
Reserve the judgment.
I'm sorry.
And what is the pressing urgency?
Your
You
Lordship,
think
I'm
that
sorry.
the day I pass an order, the vessel will be taken out from the Indian water?
No, Your Lordship, I
Despite
rendered-
the fact that admiral shoot is pending?
I'm sorry, my lord. It should not have ever come before this.
You have filed a voluminous record. You want that the matter should be, your client will give dictation to the court saying that you pass a judgment today or tomorrow. And I am getting ready my indemnity bond. How does he know that I'll pass the order in his favor? Tell your overseas client that in India, rule of law still prevails. Don't try to overreach the court.
I'm sorry.
Tell your clients. They may be foreigners, they may be big shot. This is a constitutional court. Get that order. Get that letter. No court will tolerate like this. Where is the proceeding? Right now, this matter was heard extensively for more than 5 days of hearing. Spending about spending a couple of hours due to the complex issue involved in the case. The matter was the judgment was reserved on 5/1/2020.
Because hard on length, Lordship also reflect. Is a hard on length and lot of effort has been given on each day.
Reserved. The judgment was reserved on 1/5/2024. On such and such day, on such and such day, the counsel for the petitioner mentioned before court, praying for early pronouncement of the judgment. And the court assured the counsel that need will be done. When the matter stood thus, the one Mr. One Mr. So purported to be the official of the petitioner company, address a letter to the this court. The para 3 of the letter is relevant to be reproduced. Right on. Para 3. Right on. Considering the situation of the case in which the crew have been encountering, we would hereby need your excellency assistance in issuing the judgment within today or tomorrow, so that we can prepare the necessary procedure for release of the vessel. Especially, we are preparing the bond for execution to ensure the release of the vessel in line of the judgment and regulation. How do you know that you know the line of the judgment also? You know the judgment, which judgment I am going to pass.
Out of sheer desperation, my lord. Yesterday, one of the
What desperation?
Lordship,
How can you? This is. I will take cognizance. This is a contempt.
Lordship, I sincere apologies, my lord. Just one line, my lord. I'll speak.
Nothing doing.
One of the engines has stopped working, my lord. That is the desperation, my lord.
It is a glaring instance of interfering in the administration of justice and a brazen attempt on the part of the petitioner to preempt an order from this court. I take serious note of this and recuse myself from this case. and direct the registry to place this letter along with the matter before the Honorable Chief Justice to place it before some other court, release the matter.
Should be reconsidered in light of humanitarian grounds only, Your Lordship.
Maybe you may be correct. I'm not blaming you, but you are
Lord,
courteous
just
client has
completely
to
my fault, my
tell
lord.
them that don't try to be smart with Indian courts.
Lordship, extremely apologetic for my behavior.
It's all right. I nothing to do with you. You are doing a matter.
No, Your Lordship.
Don't
They
get
were-
into yourself.
No, my
They
lord.
have
I'm just
taken
telling
content
you.
out our labor.
Lordship,
They have-
extremely
they have
sorry.
taken
It's all
content
right. Why
about
do you
the
say
voter
sorry?
card.
Your client are so desperate. What to do?
Your Lordship, because one of the
They
engines.
don't trust the
No, my lord, that's not.
Indian judiciary, yes.
court, or they think that they are smarter than the Indian
Yes.
courts. Then
As we speak, my lord, the vessel is in a very difficult situation and one of the engine turbines has stopped working. That was the sole reason we had to press, my lord.
sir, you know,
I will be excused for any mistake I
so,
have carried on.
sir, you have already prepared the indemnity bond of 100 crores, 200 crores. I don't know, because you know the lineup for the judgment which I am going to pass. So do it now.
I'm extremely sorry, my lords. If your lordship may
Please.
reconsider the same, my lords.
It's all right. Don't be apologetic. Don't take it to your heart. It is only for client. This is another matter for you. Be happy and go.
Lordship,
Tell
only
them.
22 lives on.
See,
vessel, my lord.
if we people will not uphold the dignity of our court, who else?
My lord, as officers
Who
of the
else?
court, I have failed in my duty, my lord. It shall not happen
No,
again.
no, you have done your job, sir. You have done your job. I am very thankful that at least you brought to the notice of this court the letter which they have addressed. This is a
Yes.
great job you have done.
Yes.
Thank you very much for that.
Yes.
You have done your job.
Right.
Don't take it to your heart. Don't take it to your heart. This is another case for you. See, the way these people are behaving, they deserve it. It will be listed before some other point. You argue. You get one more opportunity to argue the entire matter. Don't take it to your heart. Okay, proceed.
Item 2.
I am pardon to mention
Yes.
here 135 as per direction of the my lord's direction in injured as well as informant both are coming well. Kindly taken over 2 p.m. 135.
135? Yes, no problem.
Oh, please.
Yes.
Permitted to make a mention. Serial number 89 today's list. Defect is not removed. No entry model is there.
80?
Defect is not removed. Your
Which item?
89 my lord.
89.
89 today's list.
Okay. Adjourn.
After the session I will remove.
Yes, yes, no problem.
Oh, please.
Item 2.
Yes.
May please.
Hey, look, what is happening? Why is
Yesterday, I don't know.
all the matters? 1 to 5.
4 matters all are similar, my lord. My
1
lord,
to 4. All the connected matters.
connected matters, my lord. One informant is the same. Accused persons are the same. Allegations are same.
What is this? Why this is listed to me?
So mistakenly say, yes, he has written,
Yes,
Rare
there
of
is a
the-
confusion in this matter. See, the order, they made me to sign this order. Then I realized there is a mistake.
Yes.
But I could not recollect what exactly had happened.
yes, yes.
What is the order, what they made me to sign, my staff? As the request by learned counsel for the petitioner, release the matter on such and such.
In fact,
Thereafter, it is written, considering the submission made by the learned counsel for the parties, this court, there shall be stay of the proceeding.
my lord, in
There was
fact,
no hearing, there was nothing.
in
If
fact,
I
your
have adjourned the
lordship
matter,
said,
where is the question of stay?
in fact, your lordship said, my lord, notice to be issued to the opposite party number
Right.
2. And
What?
the connected matters, my lord, are pending, where, my lord,
In the connected matter, I have stayed.
no, connected matters, interim orders have been passed, my lord.
Let us see.
That is what I, my lord, your lordship said that OP number 2, I will take notice and these
These are the
matters to
connected
be,
matter listed today.
my lord,
No,
no, say connected matters list hai. These were directed to be listed along with the connected matters. And interim order, whatever passed in those cases, my lord, your lordship said that those interim orders will be passed in this case, my lord. In these 4 cases.
there shall be no course of action.
No course of action to be taken.
Yes, Mr.
Yes, the connected matter, CRMC number 470/2021.
467 set a second order.
467.
467, 468, 469,
Yes.
471.
তার petitioner হচ্ছে রুদ্র দাস
Yes, the other two
No,
co-accused
Rudradas.
persons.
Rudradas.
The other two co-accused
On
persons.
11/1, it is adjourned to 11/1/2023 by coordinate bench, and the interim order was continued. In that case.
So the same entry model.
Yes, that is the same ground has been challenged with this in this case. 2 to 5 are same related to that case.
Tag these matters, all the matter, tag this matter with criminal MC number 467 of 2021.
Yes.
Charita cases, 467, 468, 469 and 471.
Yes.
So second order that is submitted.
Tag with matter with 467, 468, 469 and 470 of 2021.
Yes.
2021. Mr. P.K. Mishra, learned counsel for the petitioner submits that these matters are connected with in the connected matters, the coordinate bench has issued interim direction. Issue notice to opposite party.
Yes.
Mr. Maharaja accept notice and submits that indeed in the connected matters interim orders has been passed by the coordinate bench on 8/12/2022. All right. Considering the above submission, considering your submission, no coercive action of this?
No coercive action was directed to be taken.
No
coercive action.
Above submission of the length of what the parties by way of interim measure, it is directed that there shall be no coercive action against the petitioners in connection to Chandrasekhar PS case number 84.
Sabuthre alga alga haba PS case number gudaka. The
Then
charita case re.
How it is connected then?
Connected means one informant. In all the cases, one is the informant. OP number 2.
Then he filed different.
He filed 4 affairs making out same allegations.
So PS case number so file gudaka alga alga dekhi likhiyo. Carefully write down. Yes.
Item 6.
Yes.
Maybe. It is challenging the order of cognizance on 498 306 IPC. In the meantime, the matter has already been compromised between the parties.
Yes.
Last of them, I directed to file the PM report. My lord. I have filed the PM report along with the charge sheet.
No, offense is 307.
306, my lord. 498 306.
306. Okay.
How they don't copy charge sheet?
Charge sheet, very charge sheet.
Charge sheet, I
have filed, my lord.
Right.
That is noting is there, my lord.
The PM report. Just see the PM report.
Well, they have not supplied the copy, madam.
Supply the copy, then how will they?
Just now, my lord.
Charge sheet and also.
Supply the charge sheet and
Organic phosphorus.
they say the matter is settled.
My lord. In fact, my lord, 306 case, my lord. 306 case of father, my lord, comparing matter, my lord.
Father is
306 and other offenses, my lord, that could not be said. Since the matter are serious offenses, 304B also there, my lord.
No, 498 306.
Cognizance is taken under which provision?
306, my lord.
306.
306 not a compatible, my lord. In fact, my lord, since this is not there, my lord, they have to face the trial, my lord. Otherwise, my lord, it is too difficult, my lord. How can the informant come forward and file the compromise petition, my lord? This is no more.
Is there any suicide note or anything?
No, my lord. Cause of it is poisoning, my lord. All the witnesses
What is the
stated
chemical analysis report?
that is reflected in the charge sheet, my lord.
What is that?
That is charge sheet, my lord.
Chemical organ phosphorus
Poisoning.
Insecticidal poisoning. जो औषध पड़े उसको मारा फिर.
She was recovered from your house. Where
Yes,
she has
Yes, my lord. They took at medical, my lord. They shifted to medical
but she has taken the poison in your house.
in my house, my lord.
Oh, it's very difficult. Even if
At that time, the present petitioner at Chennai, my lord. All the witnesses stated, my lord. There is a quarrel with regard to the sending of cash to the father and mother.
Lordship may expedite the trial, my lord, so that they will compromise there, my lord.
Expedite the
Lead
trial.
lead the evidence.
And the informant will depose and wriggle out of it. That's a better idea.
Better. Since this is bad, no more, my lord.
The petitioner is an accused in FIR number so and so, so and so. After investigation, charge sheet has been filed on such and such date. Cognizance has been taken and the trial is in progress. At this stage, petitioner filed the present petition seeking quashing up for the entire criminal prosecution on the ground that he has settled the dispute with the informant. The informant is the next part, the pulls up. The informant is the father of the deceased. In view of the serious allegation made against the petitioner, and charge sheet has already been filed in the case, I am not inclined to entertain the petition. However, in view of the fact that the petitioner submits that the matter has already been settled and the FIR is stated to be filed due to misunderstanding, it would be expedient to direct the court below to expedite the trial. When was the expedite the trial of the case? Accordingly, this court direct. Where is it pending?
That is pending before the prestigium Jagasham.
Not
committed.
Not same committal proceeding.
Direct the SDGM
Jagasham.
To do well to see that the matter is committed forthwith, committed expeditiously, so that the trial can commence and and after commission after the committal of the case, the trial court shall also do well to see that the trial proceeds as expeditiously as possible and the statement of the informant is recorded.
In fact, my lord, he has not been arrested. And inevitable.
Informant statement record पे कोई दिलियो?
Open.
I know.
Now, regular je he nahi. Ask karo.
That accounts for the further submits that his client who is stated to be absconding shall appear before the court and seek remedy available to him under law and cooperate with the trial so as to complete the trial as expeditiously as possible. Yes. Yes.
Item 7. May please your lordship, my lord. Petitioner is now connected in the case, my lord, but his sum of rupees 5,20,000 is seized, my lord. He filed a petition under 457, which I rejected thereafter.
5 lakhs?
22,000, my lord.
5 lakhs spent.
You are seized from my house, my lord.
You are accused. You are the accused.
No, my lord. The accused were Sampath Kumar and Manoj Kumar Panda. Thereafter, it has been dealt, my lord, in page 29, my lord. They're saying that I was financing them.
But you are not medical.
No, my lord.
And the raid has taken place from your house and
house, my lord. From my house, and the Law and Court rejected my application, saying that I could not produce any document. Those monies are belong to me, my lord.
And then
that are the investigation going on.
I submitted documents, my lord, regarding my business. Annexure 4, Annexure 5.
So now the investigation is still on. Let us understand whose money is that and all.
Yes,
it may be required. After the charge sheet is filed, then you can move application.
Whether it belongs to him or that person's matter.
Petitioner may I submit one matter? Yes. That money belongs to me, whether they are submitting that. By doing that business, I have received that money.
Sir, investigation is still on. I am giving opportunity. After charge sheet is filed, you revive. Everything will come clean.
I have on the decision authority, my lord, Hon'Ble Madras High Court as well as the High Court, my lord. In Anwar Saksa versus Inspector of Police, Hon'Ble Madras High Court, decided the past disorder.
What does it say?
Like this, my lord. considering all the aspect of the matter, it is that direction matter. The petitioner shall execute a personal indemnity bond for the like sum with one suit who is an income tax accessible. On such, in this case, my lord, the allowed in favor of the petitioner. On such execution of the personal indemnity bond, the learned magistrate is directed to grant interim custody of the currency notes to the tune of 76,81,000 by following procedural record of evidence under section 451 CRPC. Necessary bond and security bond should be obtained from the petitioner so as to prevent the evidence being lost.
What stage? The stage is
That
important.
is important.
What stage? You are right. You are absolutely
That
right.
body may be required for purpose of investigation. Now,
You are
not
absolutely
this
right. But
appropriate
it is a very threshold.
Well, I am ready to give the security matter. Se
But
money re
the-
kon achi mu ta agya ବେପାର କଲି ପଇସା
you may be-
ଏମିତି କଣ ଲେଖା ହେଇଛି ମୁଁ ସେଇ ବିଜନେସ କଲି ଏଇ
Now,
currency note
suppose
ଟା-
in the investigation they want to know the number of the note. How do you know?
ଆଜ୍ଞା ମତେ ପ୍ରଫେସନାଲ ଫି ଦଉଛନ୍ତି
All
ସେ
right.
ଲେଖି ଦଉଛନ୍ତି
All right.
ଏଇ କଥା ମୁଁ ଦେଲି ୟାକୁ ବୋଲି
We don't know.
ଆଜ୍ଞା
We don't know the
I am ready to pay
in
my
which angle the investigation is going on. We don't.
also our honorable high court citizen they my Yeshwant Porar honorable L Mahapatra
All these things will apply after the investigation is over. Charge sheet is filed. You move the application. Wait till.
case
What is the
is
stage of investigation? How much time it will
must have
take?
been completed is
That's very fast.
23 minor
Huh?
case is of the 23 minor
The FIR, the petitioner is not arraigned as an accused in FIR number so. However, a raid has taken place in his house and rupees, how much? 5,22,000 has been seized. Has been seized from his house. In the investigation is still going on. At that stage, petitioner moved an application before the
Must
court
have been
below
submitted.
under section 457 CRPC seeking release of the paid amount, which has been turned down by the trial court by the order dated 16/1/2023. I'll set aside this order, but I'll give you a question.
may I submit my
And the petitioner, again, petitioner challenged that order by filing criminal revision number 11 of 2023. The sessions judge, second additional sessions judge, Bhubaneswar, by its order dated 3/6/2023 in CRLM in the revision petition has rejected the petition and affirmed the order of SBJ. Hence, the petitioner has filed the present petition assailing those orders. I'm of the since the investigation is still going on, the petition filed by the petitioner was premature. Hence, the petitioner is given liberty to approach the court after the charge sheet is filed. In view thereof, the order dated 16/1/2023 passed by JMFC 3 Bhubaneswar in CMC number 641 of 2022 and the order dated 3/6/2023 passed by the second additional sessions judge Bhubaneswar in criminal revision number 10/11 of 2023 are set aside. Petitioner is given liberty to revive his application under section 457 CRPC after the charge sheet.
If the meantime charge is completed, then
in this case
I immediately charge sheet.
charge sheet
I have set aside all observation code.
in this case I will submit a report that the case is not no more required madam.
You are
It is in the order madam.
It is open to the petitioner to raise all the point before the court below in the press application which he is intended to move.
revision petition dismissed on the ground that investigation going on.
That's right.
For that reason.
I set aside everything because that will be a stumbling block for him. Yes, next.
Obliged.
Item 8.
Yes.
Item 8.
Defect of sheet, 8.
OPID matter, my lord.
OPID.
Nobody appeared.
कितने मीटर से टोटल है? 100.
141.
141. Pass over it now.
23 ଟା ଆଠ ଜଣ ହେଇଛି 20
ଫେର ବି ତ ପହଞ୍ଚିବାରେ କଷ୍ଟ ହେଇଯିବ।
8 ଜଣ ଆଜି
Adjourn କର. None appears in the interest of justice. Adjourn.
Item 10.
Just check it up. Display board.
10 where tribunalship. Here Miller petitioner seeking of quashment of the proceeding on the ground that though the informant not belongs to the SC/ST community in view of the annexure 3 report of the Tahsildar concerned for the prosecuting agency submitted Miller charge sheet, SC/ST and other allied offences. Look into the annexure 3, the report of the Tahsildar Miller. Inquiry report running page Miller 27. 27. Column number 3. Hira Badiyar Singh is the Miller informant. Religion is Christian. So
Hira Badiyar Singh.
Hira Badiyar Singh. She is the informant.
27, huh?
27 page.
Where is that?
Serial number 3.
3, okay. Hira Badiyar Singh.
Christian Miller, social, religion, and economic backward SCBC.
SCBC category. ठीक है.
Christian Miller, religion Christian, not SC/ST.
So therefore,
the submitting Miller charge sheet offense under section 3 SC/ST.
no, it is written caste is Dumbo.
Seita Miller has a caste, but Christian.
Christian, huh?
Christian.
Caste is more important. Religion maybe.
caste Christian community also
Maybe. Hindu.
SC/ST also they are
Hindu maybe SC/ST also.
हाँ, माने.
Christian maybe SC/ST.
नहीं हिंदू SC/ST ହେଇପାରେ ମୁସଲିମ ହେଇପାରିବେନି କି ଖ୍ରୀଷ୍ଟିଆନ
କେମିତି ହେଇପାରେ ମୁସଲିମ ସବୁଥିରେ ଅଛନ୍ତି ସବୁଥିରେ
That is why it is India.
charge sheet submitted my lord
charge sheet SCBC ଅଛି
after
SC/ST ନାହିଁ
thorough investigation charge sheet submitted.
SC/ST ନାହିଁ ତାଙ୍କ କାଷ୍ଟ ସାର୍ଟିଫିକେଟ ସେମାନେ ଦେଇ ପାରୁନାହାନ୍ତି
Caste is important or religion is important? You are
Caste,
showing me
but they have not submitted
caste is Dumbo.
during investigation they Miller ଏଠି ଅଛି ପା Miller category ହେଲା SCBC social Miller economic background.
No, this is again, now cognizance is taken.
Yes, I was on bail also.
you raise this point at 5 framing charge
Yes, that
Then counsel for the petitioner fairly submits that he would withdraw this petition to raise the point before the court below at the time of framing of charge. With this liberty,
my submission Miller record
yes.
Though the prosecuting agency submitted charge sheet. After investigation, the police had filed charge sheet on 2/4/2023 for alleged offence under section 323, 294, 354, 506, 34, and section 3(1) RS and 3(2) VA, small VA, page 15 VA of SC/ST. Counsel for the petitioner drawn my attention to annexure 3. Inquiry report of that.
Annexure 3, which is an inquiry report to submit and submitted that the complainant Hira Badiyar Singh is stated to be a SCBC category. SCBC category belongs to SCBC category and by his religion he is a Christian. Therefore, the offence under section alleged offence
under SC/ST
under section 3 and 3(2) and 3(1) of SC/ST Act is not made out. Not made out. The other offences will remain. Yes. So therefore, charge is the only. Yes.
Item 12.
Yes. Yes, sir.
My lord, in this case, my lord, I challenge the initiation of the proceeding that is in annexure 12, my lord.
Annexure?
Annexure 12, my lord. Page 47.
Yeah.
Lord, the case is just like this, my lord. That these two petitioners, the loanee and guarantor, my lord. and obtained loan from the OP number 2 and 2 my lord. The 2 and 3 OP number 2 my lord. 2 and 3 my lord. They are private company my lord. Non-banking financial company my lord.
Case pending before the Calcutta court, my lord.
That I am saying.
This court, my lord,
That I am coming to that point. I'm coming to that point. My lord, that was accident took place at Keonjhar, my lord. Lost the FIR there. Thereafter, the vehicle was taken to this Cuttack, my lord, for repairing, my lord. And at the time of repairing, I had paid the amount of 2 lakh rupees, my lord, that I have annexed the bill, my lord. After submission of bill, my lord, when they were repaired, my lord, he said demanded 12 lakh rupees. I could not pay, my lord. Thereafter, I surrendered the vehicle, and that was taken in their custody, my lord.
It's all right.
And my lord,
Come to your prayer.
Tell your lord.
Prayer, my lord.
The prayer coach. If the jurisdiction of the company is Chennai, jurisdiction of Jagatsinghpur. Entire transaction took place in Orissa, Jagatsinghpur registered at Jagatsinghpur, Keonjhar accident, and repaired at the Cuttack, my lord. So entire jurisdiction within Orissa, my lord, at best. And but now they are saying,
where is the case pending?
Well, now they are saying that we have a branch office at Calcutta. We have lost the FIR at the Calcutta. My lord.
And therefore, you have to go to Calcutta.
Your lordship kindly. Calcutta, and because thereafter, my lord, we have lost the complaint case, my lord. Though arbitration proceeding were there and there, my lord.
Everything is correct, but how can I exercise my jurisdiction?
My lord, that is correct, my
in
lord.
Calcutta.
Metropolitan Magistrate, Hard Court, Calcutta.
My lord. Because without jurisdiction, they have done it, my lord.
Then you would go to that court and say that you don't have jurisdiction.
Because
I can't decide whether that court has jurisdiction.
That point I understand, my lord. I very much understand. Right. But fact is, my lord, as a private company, how they are harassing the people by taking the case to the other, my lord, which has no jurisdiction. Because at the time of entering agreement, he was in Chennai, the rest of Chennai.
What can I do? You tell me.
Well, your lordship,
everything is correct.
Your lordship, you take issue notice against them, my lord.
How can I issue notice? Matter is pending in Metropolitan Magistrate.
My lord, your lordship say, they will say, oh, what has happened?
Come to your prayer. Come to your prayer. You are simply saying, was the criminal prosecution in CH case number so and so in the Metropolitan Magistrate Calcutta. How can I issue notice?
My lord, because of this, my lord,
and the Calcutta people will start laughing at us.
My lord, your lordship, I understand your lordship point, my lord. It has got no jurisdiction.
You should have modulated the prayer. Something so that one
decision ଅଛି ଆପଣଙ୍କର ଅଛି ଗୋଟେ decision ଦେଇଥିଲି transit ରେ ଯାଇକି ସେଠି appear କରିବେ ଏବେ ବି ଅଛି
your prayer is
against you ତା ପ୍ରକୃତ jurisdiction ସେଠି ଅଛି ତାଙ୍କର କିନ୍ତୁ କଥା ହଉଛି ଯିଏ ମାନେ ସେ ଯୋଉଠି ସେଠି ଫାଇଲ କରିବେ can be attracted
କଣ କରିପାରିବା କଣ
but innocent people will be attracted.
What kind of order I can pass? You tell me.
Simply, your lordship can issue notice there. Because it is a purely civil matter.
No.
Purely civil matter, my lord.
No, this will be a mockery.
And though it has been taken, though it has been taken,
he is not asking that.
That is not being reflected.
He is asking quas the Calcutta proceedings.
Your lordship.
Simply withdraw to move.
Other offense,
notice branch ଅଛି ଜଗତସିଂହପୁର.
How can I issue notice? Everybody will laugh at the court.
Other offense with them, my lord. He can approach the apex court and transfer of the case.
You better you file a transfer petition in the Supreme Court.
Supreme Court. Transfer as late.
No jurisdiction is not a ground for transfer. Still, you can move.
Your lordship.
Then counsel for the petitioner seeks to withdraw this petition to avail appropriate remedy under law with the liberty with such liberty dispose. Better you.
My lord, I understand your lordship's predicament. I understand, my lord. But here difficulty is, my lord. But how innocent people is harassed, my lord. Enter jurisdiction is a different place. Now they are saying that another place. This is without jurisdiction.
In the 138 cases are also like that.
138 always.
You go and deposit.
सेठी बरो चेक ऑनर कले एठी किछि नाही ता कंपनी में नाही कंपनी और सब्सिक्वेंटली
you go and move an application there. You don't have a jurisdiction. How can you maintain it?
My lord, that is correct.
The court will understand that. Move the application.
Obliged.
Yes.
Item 13.
Yes.
Your Honor, questioning of Cognizance, as it has not been filed.
None appears for the petitioner. in this petition, the petitioner is seeking quashing of the cognizance order dated 19/10/2022, passed by
SDGM Keonjhar.
dated 27/11/2020. 27/11/2020. 2020. However, charge sheet, copy of charge sheet has not been filed. Adjourned. Next.
Item 14. Particularly here, my application also 311 was rejected, my lord.
Yes. 14, huh? Yes.
My
Yes, sir.
application also 311 was rejected. Challenging the order I pass application code, my lord. But under annexure is my application, my lord. For
Which
recalling-
annexure?
Recalling the period one, my lord.
To provide, to enter into a fuel supply agreement with the coal supply companies, that is MCL or CC. Now, as per that policy, the MSME's requirement is to be identified by the DIC, and DIC will recommend it to the nodal agency, which in this case is Odisha Small Scale Industrial Corporation, OSIC, and accordingly this coal is to be distributed. Once they deposited the money, the coal will be distributed. This is the policy.
Yes.
Now, the allegation here is this, there are certain farms which have availed this benefit under the coal distribution policy, and they initially it was fake, so they say it is fake, subsequent on inquiry. This is the allegation. I am, my lord, working at that relevant point of time as a raw material manager of District Industrial Center, Cuttack. Now, the role attributable to me is this, IPO has recommended about the requirement of the MSMEs. I, in turn, recommended the same to the GM, General Manager of DIC. He approves, send it to the OSIC, and then they have received. Now, the
File has gone through you.
my lord, the file has gone through me.
120p.
Yes, my lord. Now, the government has refused to accord sanction to the general manager and the IPOs. I was retired by the time filing of the charge sheet. Now, the cognizance nonetheless was taken against one such IPO, and he has approached this honorable court. This honorable court quashed his proceeding. So,
Proceeding.
Proceeding against that.
The other people.
Yes, my lord.
Due to lack of sanction.
Yes, my lord.
Yes.
And here also, apart from, admittedly, 19 will not apply because I was retired. Admittedly, there is also offenses of IPC's offenses. So that will, for that, no sanction has been accorded, even if I am retired. And which I want to address your lordship, that whether this act which has been alleged against me is an official act or not. If the answer is yes, then for 197 is required. Nonetheless, I am retired. And lordship knows the recent judgment of Lab Singh and other things that.
Yes.
So far as this petition is concerned, sanction is not required.
And 19 sanction is not
required.
But it says 197 sanction is required.
Even if 197 is concerned, that is in recent judgment and referring to the earlier judgment.
See, what he says is, forget about that offense. IPC offenses are there. Even if he's retired, 190, if it is coming under the color of duty, 197 is required.
197.
That's what his case is.
Yes. So far as
that
this,
is what your lordship is to say.
Yes.
thing is that, so far as the offense under section 468, 120B, 471, this petition recommend in respect of the farms which are not in existence at all. And he verified the spot and given the report, along with other accused persons. They connived with the 49,000 lakhs, something has been misappropriated in respect
that can't come under the color of duty.
And at the recent judgment, your lordship kindly see.
What?
My lord, the judgment relied by my lord senior, that is all, everything has been relied, and your lordship kindly see.
And what my learned friend is saying, that must be borne out of the record. I've given the charge sheet. My role has been clearly and categorically stated.
120p.
Yes, my lord, I'm coming there. Why even for 120p, if it is in the color of duty, sanction is required. That's not in dispute. My lord, kindly see the evidence at 147. That's the charge sheet. I'll address with all my written notes and judgment. No,
these are legally. But he.
Yes, I'm conscious with that judgment, and I have already
number
10
of judgment. Number
10
of judgment,
numbers of
this
judgment I have.
has also held that.
So I am conscious of this recent judgment, even it is on that point. That
The problem, I'll tell you, the problem is you like seniors or making him wiser by giving judgment?
No, 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 I'm not. I'm not
this
saying that I'm. The
Refer-
latest judgment is this key. Yes, the distinguishing factor which your lordship is to reach is that whether from the imputations on record, is it a duty, official duty and discharge is imputed, or I have done something beyond my official duty? That's the case.
That's the,
That's
How it will
Lordship
be
will step
if it is
into
coming under the color of duty, then 197.
197.
Otherwise, no one.
No,
And-
that's, I will be limiting myself to that.
And-
Lordship
And
takes it
referring
the
to
next-
all judgments.
Yes.
This honorable court, an honorable apex court has held that whether it is coming under the
No, no,
official
judgment is all right, but he wants to make out a case on facts.
on
That's
fact,
it.
then it will be held. It will be decided on trial by letting evidence. That is the judgment.
Undisputed
Not at this
facts.
stage.
Undisputed facts. I will not to say.
But
in-
you have to.
I know that judgment. I will place your lordship.
Then why can't you reserve that liberty and argue?
No, and the already this honorable
What
court
he
has.
says is, even if you are correct,
Well,
if the court comes to the conclusion it is under the color of duty, then also cognizance order cannot be passed because it has to be tasted at the final stage.
Lordship, may I see it from the other angle. Now 120B I am being charged. Now my lord, the bottom officer is out. The top officer is out. I am the recommending situation.
Therefore, instead of wasting time, you face the trial, you will be acquitted.
Well, that I'll come back with your lordship with distinguishing that judgment. Let it
Okay, immediately after.
Oh, man, deeply obliged.
But it's better that I will expedite the
No,
trial so that it will be easy for you.
Let me.
This point.
No,
Dog-
I will
dog
try.
must
If
have
I will not going to waste your lordship's time much. I'm already limiting myself. I'll be addressing on
See,
that.
2010 FIR.
Nothing has happened because
14 years.
other matters are still pending before this honorable court, and they have lost in some cases. They have not assailed it. My lord, I'll bring everything up.
There is a question of law. If
I'll-
sanction is refused, what will, how can we argue?
I'll.
But even if I expedite the trial, since other matters are pending.
Pending, that's.
नहीं नहीं सत्रे other matter रे कुछ stay नहीं.
The stay, the other matters are there. Already
Because
the
they are
most
filing
challenge
a
are there.
petition here and seeking adjournment there.
No.
That is the problem.
What is your age now?
And my age is more than 17.
Are you waiting for something else?
Not like that, man. I was waiting actually that the initial challenges of others to succeed, and it's a fact that once they have succeeded, I come back to it.
Okay. All the best.
Item 18, lordship, compromise matter, matrimonial.
Here, at the proposement of the proceeding, lordship see at page 11.
11.
Yes, ma'am.
Yes.
Here, at the instance of one Subhasri Padiyari, he is working as MPSW, multi-purpose health worker female at Regional Life Institute of Unani Medicine at Bhadrak. And the petitioner is working as library information assistant at Bhadrak since 2015. And that informant joined in the said institute in 2016.
Yes.
And lordship, besides other allegation, from the very inception, at the instance of the petitioner, she was given that some sort of sexual assault. And lordship, see at page 10, against all employees belong to Muslim community, FIR has been lost. Lordship, see at page 10. Accused persons are 8 in number. I am serial number 1, Suhail Akhtar. And lordship, see at page 12, page 13. Yes. Here, in the name of that converting the Hindu people to Muslim, that was the allegation. Besides other allegations, during the, working hour,
yes,
that allegation of forcible sexual act is against her. And besides these 8 accused persons, I am alone charge treated. Yes. Page 13.
Allegation is 376-1.
Yes.
376-2N.
Yes.
294 and 506.
Yes.
Why should be quashed? The cognizance should be quashed. You tell me.
No, that is no
That's
cognizance.
it, something.
Charge sheet cognizance is yet to be taken. You have seen para 13, page 13. Madam.
You tell me what is the case.
No, in fact, both are health from a same institute. She is working as MPSW. I am working as a library information assistant since 2016. She joined at 2018. It's 2016. Ever since date of joining, she alleged that I have been torturing her in somehow, some plea or the other. The matter was never brought to the any of the authority or reported to the local police. And also see the incident in question took place in 2018. This affair laws in 2023.
Absolutely, you don't have a case. You look at it on any angle, you don't have a case. What to do?
I don't.
You have not also implemented the.
Actually, may I pray for one thing? Possibility of that compromise cannot be ruled out. Let the informant be noticed and.
You have not implemented here also.
I am permitted to implead as a party.
Better even at a time framing charges.
Are you in relationship with her?
No. Because you see the affair, all employees, health from Muslim community, all have been implemented as accused. Against them, besides sexual assault, allegation that they are trying to convert the Hindu people from Muslim community. That was the illegal sentence. But I have an alone charge sheet.
The petitioner seeks to implead the informant of his victim in the present case in the opposite party number 2. Let him do so during the course of the issue notice in the opposite party. Yes, issue notice. Yes.
21.
Permit to implead as OP number 2.
Yes, yes.
Let notice be issued. I am serving extra copy or let.
Yes.
May I pray one more thing? Case is posted to Friday. May I permitted pray time petition before the learned court in session about the matter.
I am doing some grace to you by issuing notice because something may work out. Therefore, otherwise you don't have a case. Not at all a case. Not at all a case. Yes.
21.
On behalf of Mr. Rai, take note on day after tomorrow. He is out of station tomorrow.
Adjourned.
23.
The fake certificate, your lordship, our of the fact, that is a fake B.Ed certificate. Before your lordship, it is the student which passed first class in matric, lost in first class, but there is insufficient of the B.Ed certificate which is drawn.
Even then you
that the B.Ed certificate, he has no knowledge of, he has no knowledge of where the certificate come, but he has exam and passed, and so certificate from the Sahuji Maharaj University. Then he in the junior teacher.
Sahuji Maharaj University is very dangerous. But in Orissa, every B.Ed certificate is Sahuji Maharaj.
But the petition is from the both universities in rural area. He know about the 2019, there is no internet. After the corona, the internet situation is developed. Your mobile.
You are working as a teacher.
Yes, ma'am. So that what we do, my lord, is a lady, my lord. The charge sheet has not filed, my lord. I pray your lordship only surrender the petition so that he is.
Offenses are 24, 68, 46.
Yes, offenses, my lord.
Admitted.
I admit, my lord.
Bail rejected. Bail rejected.
Yes, bail is not rejected, but he is not inclined to grant bail. Not rejected. That is not rejected. Inclined.
So
yes, my lord.
Not inclined to grant bail means not rejected.
Bail stands rejected, my lord.
That's the problem. How will I supersede this order?
I know very well, but it cannot be superseded. I find it for
you burn your fingers and then you come and
yes, I know. You know, see, our the fact, but it is I find it for it to application so that you have lots of no the Bhajanlal case to still today, my lord.
Bhajanlal says that even if anticipatory bail is rejected, you grant
no
anticipatory bail.
I cannot say that.
That's what you are saying.
No. I said the inherent power of this one, so that is a lady, my lord.
Inherent power to quash the FIR. Yes. If at all there is merit.
Yes, my lord.
You yourself knows there is no merit. Investigation is still going on. FIR is registered recently. Even then you are bringing Bhajanlal.
Yes. I pay one time pay cost, my lord. Any I pay to cost or any ton
condition. Not the issue. The issue is how to mold the relief so that you will not be arrested. That's the issue. How to mold the relief? You tell me.
I pay one thing, my lord.
You have burned your finger by getting your anticipatory bail rejected. What to do?
I pay only your lordship.
When will you appear before surrender before the court below? I will not surrender. It is anticipatory bail.
Your lordship surrender.
And in government condition, we pay the cost for the 1 year were lost.
I'm not saying for appeal over this order, sir.
Yes, yes.
That's the problem. If you would not have gone to anticipate bail, something could have been done. If coordinate bench passes some order,
Yes,
for
yes,
it, I'll nullify that.
I felt
The rule of law has to
but
be,
only in the ladies. So that you are
maybe these things you should have told that court. What to do?
and after application, only after application.
Simply urgent.
Still today, my lord.
You won't tell.
Still today, my
The only relief is Mr. Ragda.
Yes, my lord.
Simply
Still
urgent. Simply, nothing can be done. Investigation is still in progress. Mr. Ragda seeks an adjournment. I am not saying that you are seeking adjournment to seek instruction regarding the stage of investigation. Adjournment.
Yes.
Yes, sir. Page?
Page 14. ma'am.
On
The statement of the mother and the brother, 14 and 15. My lord, here, my humble submission before your lordship is, my lord, 498 will absolutely not be attracted because your lordship knows, my lord, valid marriage is a sine qua non for attracting offense under section 498. Here, the statement of the mother clearly reveals that the girl had married to another person and there was some quarrel between both and she came back. And in the village, after that, my lord, without taking divorce from the first husband, my lord, she married the present petitioner and was staying there, my lord. And thereafter, takar allegation. But even accepting that also, my lord, it is not a valid marriage, my lord. Because during the subsistence of the first marriage, my lord,
unless the court of law give a declaration.
Unless the court of law gives a
Have you
declaration.
sought for a declaration?
But here is a case, my lord, your lordship may kindly look at the statement of the mother. Ajita 24/10/2022 page 14, my lord. Ajita 24/10/2022 लिख दिन आपन निकट देबा बयान एही कि जे मो झियो सत्या गोटे पुओ को भल पाई विवाह करथिला तार औरसरु दुई गोटी झियो जात होइचंती तांक मध्यरे विवाद हेबारु झियो सत्या तार दुई गोटी झियो को नेई आम गार रहउतला इति मध्यरे गुणपुर स्टेशन रोड साहिर चिरुकुला रमेश सो my lord, then my lord, the role of the present petitioner has been then all page 15 is the brother also.
Gunupur Ayappa Mandir re vivah karthili. Then
but this marriage cannot be treated as a valid marriage because the first marriage she has not taken divorce, my lord. The first marriage is still subsisting.
Somebody has to declare that the marriage is invalid. You can't declare yourself.
No, I am not. The court has to declare, my lord.
Have you approached the court?
No, I cannot approach, my lord. The first husband, she had married to another person, my lord, not me, my lord.
No, you are the second husband now.
I am the second husband.
You are roped in under 498.
498.
Investigation is still going on.
No, investigation is over and cognizance has been taken.
It's a case of, in fact, it's a case of 493.
At best, my lord, 490. But 498, no cognizance could have been taken, my lord. And the London court below has taken cognizance.
The statement of the victim, the complainant, Charikula Swati. ମୁଁ 24/10/2022 दिन ଆପଣ ନିକଟରେ ଦେବା ବୟାନ ହେଇକି ଯେ ଗତ 4/6/2021 ରେ ଗୁଣପୁର ଆୟାର ମନ୍ଦିର ଚିରିକୁଲା ରମେଶଙ୍କ ସହିତ ମୋର ବିବାହ ହୋଇଥିଲା। ବିବାହ ପରେ ମୁଁ ଓ ମୋ ସ୍ୱାମୀ ରମେଶ ପ୍ରଥମେ ଗୁଲାସାହି ଓ ପରେ ବାଳକଟି ସାହିରେ ଘର ଭଡ଼ାରେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭାବେ ରହୁଥିଲୁ। ଆମ ବୈବାହିକ ଜୀବନ କାଳରେ ଆମର ଗୋଟିଏ ପୁତ୍ର ସନ୍ତାନ ଜାତ ହେଲା। 5 ମାସ ପରେ ଶିଶୁର ମୃତ୍ୟୁ ଘଟିଲା। ବର୍ତ୍ତମାନ ମୋର ସ୍ୱାମୀ ପରିବାର ଲୋକେ ମୋ ଉପରେ ଶାରୀରିକ ଓ ମାନସିକ ନିର୍ଯାତନା ଦେଉଛନ୍ତି ଏବଂ ମୋ ସ୍ୱାମୀଙ୍କ ବଡ଼ ଭାଇ ଜଗଦୀଶ ତାଙ୍କ ମା କଲ୍ୟାଣୀ ମୋର ସ୍ୱାମୀକୁ ପ୍ରବର୍ତ୍ତାଇ ମୋତେ ନିର୍ଯାତନା ଦେଉଛନ୍ତି। This is
her statement. She says, my lord, on 4/6/2001 this man came into
All
her
these things
life.
are a cognizant stage. I can't.
My lord, cognizance stage, my lord, the 498 offense is absolutely not made out because, my
you
lord,
argue on charge.
charge framing time cognizance could
See,
not
I
have
can't-
been taken.
See, there is one
the
version
basis
against other.
These
The
materials.
victim says one thing, and the
No, victim doesn't say the previous part, my lord.
so this has to, all these things has to be tested, sir. I can't at this stage in a
But the-
cognizant stage. I can't.
2022 your lordship will.
It may so happen that in the
Agree.
charge says instead of 498, something else may be framed on the basis of charge sheet.
ମୁଁ ଖାଲି ଟିକେ ଦେଖେଇ ଦଉଛି ହଁ ସେଇ ଗୋଟାକ ସେ ଯୋଉ କହୁଛନ୍ତି ଚିରୁକୁଲ ଯୋଉ victim ର statement
Your whole case is the statement of the mother of the victim.
the daughter she is not uttering anything my lord prior to that my lord. My lord, now the mother and brother both have said
You are trying to find out defense in one statement of one.
defense
There are many other.
ଆଉ ଗୋଟେ statement ଦଉଛି
defense ର question ଏଠି ଉଠୁନି because their own admitted case.
So what else? What else?
ଆଉ ଗୋଟେ statement କହୁଛି page 20 ରେ ଇପିଲି ମାଟିକଣ୍ଟା ଯିଏ କି stood as a ପୁରୋହିତ in the marriage. He has stated that ଗତ 4/6/2021 ରିକରେ ଗୁଣୁପୁର ଆୟାର ମନ୍ଦିର ଷ୍ଟେସନ ସାହିର ଚିରିକୁଲା ରମେଶ ଓ ସ୍ୱାତି ଉଭୟ ପବିତ୍ର ଆୟାର ମନ୍ଦିରରେ ଈଶ୍ୱରଙ୍କ ସାକ୍ଷାତରେ ଏବଂ ପବିତ୍ର
I am not disputing those things my lord, even accepting my lord for a moment.
While testing cognizance order, I can't declare the first marriage is the invalid. Second
No,
marriage.
your lordship is not to declare my lord, they had to get it
Do you
declared.
have any other point except?
No, ଏଇଟା point ରେ ମୁଁ କହିବୁ ହଜର ଟିକେ ଖାଲି your lordship may grant me 1 minute time my lord. I will even assuming all these statements are correct my lord, the fact remains that she had married to another person prior to the, your lordship knows under the Hindu Marriage Act my lord, second marriage is invalid my lord.
Now you tell me, you answer one thing.
Yes.
If the police says that 498 is made out and the charge sheet is filed, it goes to the court. Court
has to apply its mind.
On the basis of charge sheet, court can't say that no, 498 is not
No,
made
no.
out. 493 is made out. How can I
493 भी ଆସିବନି 493 भी ଆସିବନି
let the
Because-
charge court
yes.
take the charge. No, cognizance I can't quash everything.
cognizance particularly ଏଇ offense ରେ make out ହଉ ନାହିଁ ଏଇଥିପାଇଁ ମୁଁ କହୁଛି ଯେ because there was a previous marriage of the girl, not me my lord. Girl had previously married to another person.
That the mother says.
Mother and brother both says that.
And apart from mother, there are other witnesses also, those who say that you have married and prove.
Marriage ମୁଁ କରିଛି ବୋଲି that is the allegation my lord. That is the allegation even accepting that there was a marriage.
Are we not wasting time? You know that.
My lord, not
You know that
exactly
your
wasting-
case, you have
But
pitched the
why-
case to the best possible.
What I want to impress upon your lordship my lord, that my lord, there
I'm
was
already
a
impressed. You
my lord,
argue all these things.
the girl had married earlier my lord. I am just my lord pinpointing the situation my lord. The girl had married earlier to another person.
I understood this much. I can't understand.
ନାଇଁ ସେଇଟା ମୁଁ କହୁଛି unless she gets a divorce from that husband my lord,
Again,
he cannot enter.
again you are saying same thing. You are. Can I come? Can I put it in straight language? You are saying that the mother of the victim, mother of the girl, says that he had already married someone else. 2 children were born out of that marriage. Without divorce, he came, fell in love with me, and got married. A son was born out.
Exactly on the similar question, my lord.
Unless the first marriage is first marriage is nullified, the second marriage is invalid.
No, my
So
lord,
498
exactly on the same set of facts, my lord. There is a decision of the Kerala High Court where, my lord, it has been categorically held, my lord, unless gets the divorce, the second marriage he cannot enter. And 498 is not absolutely not attracted in such a situation, my lord. Your lordship may call it sometime.
Mishra and for the petitioner relying upon the 161 statement of the mother of the informant submits that the victim only the informant had already married to one. Where is that?
My lord, 2-1.
2-1.
ନାଁଟା ବି ଦେଇନାହାନ୍ତି ଗୋଟେ ପିଲାକୁ ଭଲ ପାଇ ବାହା ସେମାନେ ମୁଁ ଜାଣିବା କଥା ନୁହେଁ ତାଙ୍କର ସେମାନେ ଜାଣିନାହାନ୍ତି
with someone
ଦିଟା ପିଲା ବି ହେଇଛନ୍ତି
someone and without someone due to misunderstanding, the left her husband and came back to the village. At that stage, the present petitioner fell in love with her daughter, and entered into and married in a temple. Out of the said wedlock, there is a son. Out of the same wedlock, a son was born, and unfortunately he expired. Relying upon the same statement of the mother of the informant, Mr. Mishra submits that since the subsequent marriage is not a valid marriage, therefore charge sheet filed against the petitioner 498A IPC is not certain. Mr. Maharaj appears for the state and submits that apart from the statement of mother of the informant under 161 CRPC, there are other statements. There are other witnesses, those who have deposed against the petitioner, including the informant. The petitioner is challenging the order of cognizance dated. Order of cognizance dated 28/23, whereby the court below has taken the cognizance of offence under 498A CRP. I am not inclined to entertain this matter at this stage. However, the liberty is granted to the petitioner to apply petitioner to raise his point at the stage of framing of charges. Is for framing of charges. With this liberty, the petitioner is disposed. Yes. Yes, please.
28.
Madam, in this case, the petitioner is before your lordship for the
item 28. Can I press for a small pass over? Because it will likely to be quashed. Likely to be quashed. I have telephoning instruction, but written instruction I am waiting. He is sending. That will be after lordship.
He is trying to. He is going to concede in your favor. Yes.
29.
May I please your lordship?
Yes.
My lord, petitioners challenging the order of cognizance passed by the Lord and Magistrate, my lords. Petitioners are working as drivers and conductor of under OSRTC.
Yes.
On the date of occurrence, police hoisted such case against the petitioners, alleging that basing upon the reliable information, police party went to the Lanjigad bus stop and got some materials from the luggage compartment of the bus, and accordingly initiated a case against the petitioners, and accordingly investigated and submitted charge sheet, and Lord and Magistrate was pleased to take cognizance against the petitioners. I have a ground only without taking any sanction from the authority concerned. Lord and Magistrate took cognizance against the present petitioners. And also, there was no scope to know.
What are the offences?
Offence 379 and 34 of IPC, my lord.
This is coming under your color of duty.
Yes. While petitioners were on duty, such case as for...
While in duty, they can murder. While in duty, they can theft. While in duty, they can do anything. And a sanction is required for that.
No, the case is
it coming under your color of your duty? Theft?
There was no scope to know what documents, what materials supplied through the bus.
That may be your defense.
Not that is fact of the case. That is fact of the case.
Yes. What else? What else you have, sir?
Sorry, my lord.
What else? Next point.
Next, without taking sanction, Lord and Magistrate was pleased to take cognizance against the paper. All the petitioners are employee of the OSRTC.
Sanction under section
Even
197.
yes, even they have no knowledge. At the time of occurrence, they had no knowledge. They have no knowledge regarding transportation of any materials.
Except sanction on merit, what you have?
My lord, even if they have no involvement in this case also, may I permit to place a few lines of the written report?
Where are the 161 statements you have not filed?
Once, may I permit to place a few lines of the written report? At page 11,
Yes,
my
yes,
lord.
yes, Mr. Bhaskar. Merit.
Kindly turn to page, charge sheet page, second page, from the last.
Yes.
It starts from the fact of the case. This case was registered on 28/9/2023 at 9. Complainant Karunakar Munda, aged of 49 years, so and so, bearing up area MS Vendata Limited, Vedanta Limited, Lanjigarh, and looking after the security in and around the premises of Plant Township. Today around 10:30 AM, they got information from their intelligence team that some copper materials was placed in the bus luggage compartment. Immediately he was reported to the PS. Our police team without delay flung into action and nabbed the culprits and seized the materials. This is the
I am not
circumstances.
disputing. I am not disputing, my lord and friends, Samisa. I am not disputing, but petitioners had no knowledge regarding transportation of.
You have to prove in the trial.
Regarding that, only investigating agency regarding this, my lords, investigating agency has not investigated. Who has brought the materials? Where that materials has brought? Why brought? How?
The petitioner includes in FIR number 2. The implication of the petitioner is that but they were nabbed by the police.
May I pray?
While carrying
May I pray regarding such regarding 197? I have some judgments. May I pray? Any other day will place some judgments.
You tell me the citation. I'll take it out.
Your lordship may keep it any other day. Will place the matter.
You know, you tried your luck. You know the
but no. Your lordship nowadays your lordship is the best judge for our bar.
No. Best.
Even I could not able to get time for preparation. That's why I am unable to place.
But you don't have a case.
But I have case. May I permit to try? The poor employee, they have lost everything only basing of mere cases.
Yes, next. Item 30. Today, just we are item 30, 12:15.
Senior counsel Dipu Dhalu is arguing sitting in this court.
He was sitting just now.
Another matter is
the moment he comes, you tell me.
Yes, madam.
I'll take it. No passover. Huh?
Yes, madam.
Yes. Passover for the minute, for the moment. Yes. 31.
31.
Yes.
Their compromise has been made. Lordship has told me on the other day that they brought them. I have told them to come at 2 o'clock, my lord.
They will come.
They will come.
2 o'clock, let them come. 2 o'clock. Call them.
I have already called them. They have come.
32. Yes. Yes, madam.
My lord, 32 bring for a Passover after lunch.
Passover, I told you, Passover it may not be possible today. I may not be in a position to take up.
One Passover.
The request of the petitioner urgent. Yes. 33. Urgent. Yes. It will not reach a 1 year. Yes.
May I please?
Yes, madam.
Application for quashing of the proceeding. The of petitioner number 1 is the brother-in-law and petitioner number 2 is the mother-in-law.
Yes.
The informant. That's the case under section 498, 323, 506, 4 of the DP. There is no allegation against the petitioners Lordship, the specific allegation, there is no
It's
specific
a case
allegation.
of 498A and all. You have not implemented the lady. Let him consider the petitioner seeks the leave of this court to implead the informant. in the
Informant,
present case,
look, today,
as an opposite party.
I may be
to,
permitted to.
Let him, this luxury you will have till July or 1st July only.
Yes.
Thereafter, everything will e-filing. There are, I can't permit you to do it in the court. So try to learn. After e-filing, physical filing may not be there. So how will you implead in the court? So try to learn not to do this mistake.
Yes, yes, yes.
And shall I issue notice, matrimonial dispute?
Yes, yes,
yes.
Issue notice
Yes.
to opposite party. Yes.
Party
Bardhan Karan. Yes, next.
34.
My lords, after vacations, my lords,
After vacation.
my lords,
Yes.
my lords, co-acute are really on bail, my lords, except sub item, my lords. My lords, sub item, no coercive action. Sub item.
Neither you have made the injured as a party
Nothing.
No, my lords, already.
and you have not given any certificate. Many things are there.
Don't file a complete petition, what to do?
307 ନା ତେଣୁ ଆପଣ injured କୁ party କରିବା କଥା. ଯଦି compromise ହେଇଛି, if at all.
Notice was issued.
He stated that parties will
Just
appeal.
see in the sub-item you are talking about.
My lords,
Sub-item. Just see the order dated 1/9/2023.
my lords.
It says that in the meantime, it shall be open to the petitioner to
My lords,
surrender
say-
below and move for bail, and which shall be considered on its own merit, having due regard to the fact that the co-accused persons have already been released on bail,
Yes.
and the matter has already been settled between the party.
My lords.
What else you need?
My lords, 307 no power, my lords, SD Jamto.
What is this? This order is already made. Simply urgent to.
Seta
Okay.
say order.
You said that it is settled. You bring them. I'll quash it. You don't bring them. Court has given you relief till
say order to my lords, you present petitioner bail hawani.
next.
ଆପଣ compromise ହେଇଛି ତ?
35.
Page 14 pa?
ଲୋକଙ୍କୁ ଡାକି
After vacation,
35.
after vacation, my lords, no coercive actions.
What? You got an interim order? What is this? While asking, please apply your mind. Don't be so unreasonable. There is an order in favor of you. You don't. आप कोई bail bond भी मत sign करिया कोई भी.
My lords,
Shall I do it for you? Bail bond for you?
my lords, after vacation.
He says yes.
My lords,
There is an order in your favor. Why don't you realize? Already there is an order in your favor. I have already adjourned the order which has already been passed in your favor. Encase that order. I think you have not read that order. In sub-item, please read that order.
my lords.
Yes.
35.
35. Non-APS. In the interest of justice. Yes.
36.
May it please your lordship.
Yes.
Your lordship, here the case with the petitioner filed for quashing of the proceeding, man. In fact, the investigation is going on, man. But your lordship, the FIR registered on 31st May 2023, man. The Vigilance Department
He's still investigating.
investigation is going on.
Let it
But
go.
what is the allegation, my lord?
Yes.
One ex-Nazir,
Huh?
accused number 10, Ms. Chandraprabha Jena, informed the petitioners that they will entitle for some health benefits. For that reason, my lord, they applied for the health benefits, and they, your lordship may kindly peruse page number 17, the last paragraph. May I read, your lordship?
Yes.
Bhuvana Nanda Naik, he is the petitioner here, joined as revenue supervisor of social responsibility.
In the year 2019.
and 23 you need 21.
But because my lord, my lord, FIR register
I'm sorry.
my lord, चोरी के भी धरा पड़ला सेमन कोचन चोरी धरा पड़ला FIR
चोरी भी धरा पड़ुची धीरे धीरे.
your lordship में kind
First inquiry तापर registration of FIR.
they said that there is a audit report. Let them produce the audit report, my lord.
At this stage, we will produce everything.
Take a thousand pounds for the petitioner seeks to withdraw this petition to reserving liberty to approach this court after the charge sheet is filed. If cause of action is survived. With this liberty, the petition is dismissed.
My lord, they will investigate the matter for the indefinite period, your lordship.
The investigation is still going on. Mr. Sahu, then for petition submits that. He is relying upon certain documents, and he wants to submit those documents to furnish those documents to the investigating agency. If any such document is furnished by him, the same shall be considered by the High Court.
In accordance.
In accordance with law.
Great position.
You give all these things.
Already we have filed in the CRLMC, my lord. We have filed in the CRLMC. Also, we will set this.
Yes.
Grateful, my lord.
37.
My lord, no instruction from petitioners about reliance.
Land Council petition submits that.
Urgent.
He has no instruction from the petitioner. Hence, he doesn't want to place this petition. The petition is dismissed. Yes. 38. Yes. Defense 38 ना defense
38
नन PS डिस्प्ले देखो
डिस्प्ले देखो
38 very 38 none PS for the petitioner in the interest of justice. 39.
But here the petitioner challenges the order of cognizance passed by the special court, Vigilance.
Yes.
Petitioner before your lordship is the wife
Wife.
Wife of the principal accused.
Yes.
Your lordship, kindly turn to the disproportionate asset, what they have taken. Page 34.
Is it covered by?
No, আনিছি, সে ডিসিশনটা আনিছি।
It's not covered, that's what I'm asking. It's covered, then
It is covered, that I will satisfy your lordship. Your lordship will kindly.
do you have independent defense?
Yes.
Then you are.
টিকে again. 34 টাকে দেখুন।
109.
109 ତ ମୁଁ କହୁନି, ମୁଁ କ୍ଲେମ କରୁନି ଯେ ମୋର ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ସୋର୍ସ ଥିଲା, I have ମୁଁ ସେଟା କହୁନି, କହିନି ସେଟା, ସେଟା ଏମିତି ଦେଖଉଛି କାଲି ଟିକେ ଆପଣ ଟିକେ ଦେଖନ୍ତୁ।
Then if she doesn't have independent defense.
She's claiming that.
Claiming, then he doesn't have anyway. 2 years.
Page 34.
34.
Minor. The check period is 21/7/89 to 8/5/2012. The husband of the petitioner entered into the government service in 88 as a OFS officer. He's a OFS officer. And the serial number 1, the serial number 2, my lord, that the old one double-storied building over plot number so-and-so Samantapur in the joint name of SO and his wife. Gifted ethics square feet, portico so-and-so, so-and-so, so-and-so. My lord, serial number 1, that property was purchased by the mother of the petitioner in 1996, my lord. Thereafter, she constructed a house over it and gifted the property in 2012. Next, my lord. Gold ornaments, serial number 4. Gold ornaments of the petitioner. I cannot say, my lord, I can say that I brought it from my parent house at the time of marriage.
Yes.
These are the two things, and these are the two things which the vigilance have taken into consideration to implicate me under in this case under section 109. These two things, they have not given any opportunity to the petitioner to give explanation as to how it will be included in the year. And now your lordship will kindly see how much the page 40, my lord. The percentage 76.94. Less than 100. 76.94. Except this, there is nothing against the petitioner who is a housewife, my lord. I am not saying that I have some independent source of income. I have purchased these things. My plea before your lordship that the property which was included in the assets, my lord, that property was acquired by the petitioner along with her husband by way of a gift given by her mother, my lord. And the gift deed was executed in 2012. The property was purchased in 96.
Why this gift deed was prepared just before the check period? 21/4/2012.
Well, after the gift deed was.
Is it not created to create a defense?
No. Man are killer.
But these things has to be tasted.
Your lordship will kindly see.
The lordship, page 7.
7.
Paragraph 11.
7 of what? FIR?
No, it's a petition. Petition. 3 to 4 line below.
Yes.
Para 11. It is further humbly submitted. The petitioner carried on her own business and is an income tax. Paragraph 11. It is further humbly submitted that the petitioner carried on her own business and is an income tax assessee since 1992 and 93.
10 years before the raid was.
Your lordship got it. Then your lordship come to
What business does he have?
tuition. Your lordship then come to 33.
33.
My lord.
30.
Roman 3A.
From petition.
नहीं तांकर annexure.
33.
हाँ. Running page 33. Lordship got it. Roman 3, property statement.
Property.
During investigation, it was found that Pradeep Kumar Behera, the SO,
1 minute, 1
Madam,
minute. It is there. 33.
33, Roman 3, table below the table.
Roman
Roman 3A,
3.
Roman 3, property statement. During investigation, it is found that Pradeep Kumar Behera, so and so, has not submitted property statement properly to the competent authority during his entire service tour, except for the period 2009 to 11. He had neither taken any permission for acquisition of movable and immovable assets from the competent authority, nor intimated the competent authority for acquiring the immovable assets and costly valuable movable assets in his name and the name of his family. That requirement, it is not coming under the loan sources of income. Then your lordship turn to the gold ornament, next page. In the name of the petitioner, 10,57,000 टंका gold, cash from the locker. Then para 6.
husband ro.
ମୁଁ କହିଦଉଛି ଆପଣ ଟିକେ ଦେଖନ୍ତୁ, cash from the locker, that was 13,56,000. Your lordship kindly this visualize the manner of acquisition. Then your lordship turn to,
What is he working?
he was acting as a finance officer and he is extending training.
Officer.
He is OFS officer and extending training in the academy. In the matter of finance.
At that time.
Gopalganj Academy. Your lordship then come to.
Again, ଦେଖନ୍ତୁ 75%.
Percentage of that.
କହୁଛି
Your lordship then
75%.
page 40. Your
You
lordship.
don't have a case.
Well,
You don't have.
Then-
The Cognizance says I'll not go.
then your lordship for page 40 different.
No, I am
Now that defense has been
not
rebutted.
required.
And the mother-in-law.
Says you have separate defense. You you have gold ornament, 10 lakh. And
Gold ornament, my lord.
how will I get into whether shall I start waiting? What is the weight and where from you got and all that?
And the gift is concerned.
In a Cognizance says.
And then
And if you don't have any defense, then my judgment you are covered by my judgment. And you have a separate defense, then you have to prove it.
No, so far as my lord, this case is concerned.
That's the law laid down.
My lord, that is my lord 2013, that is my lord volume 54 is here. Dimple Jadhav case, my lord.
It's not
The,
case.
the Honorable Supreme Court has held that. My lord, your lordship will kindly visualize. A property which was acquired by the mother of the petitioner in 1996.
Where from I'll get it?
I have given, my lord.
No, no.
You have given, but you have to prove it.
No, they have not, my lord, during investigation.
That's a different story, but today
No, no.
Cognizance is taken. How do you want me to go into all this? things?
During-
96, you acquired some
Then
property.
there your lordship kindly see the
And
difference.
if it is done in 2012, why for? This did it in 2012.
Take a note of that. Take a note of that the property was purchased. Your lordship will kindly see. I have, for that reason, I have.
Page
written to your
40 ଟା
lordship.
ଟିକେ ଦେଖ.
ମୁଁ ତାହେଲେ ଆଜ୍ଞା କିଛି କହିବିନି ସେ ତାଙ୍କର
ନା, ନା,
କଣ ମୁଁ
ଆପଣ
ଆଜ୍ଞା ମୁଁ
କହିଲେ।
କହୁଛି ମୋର ଟିକେ ଦିଅନ୍ତୁ ମୁଁ ସେଇଟା your lordship will kindly see they have taken note of the fact page 34 that the property was purchased by the mother of the petitioner, my lord, amount of 55,000. Page 34, your lordship will kindly see.
Anyway, that will be tasted. That will be tasted.
And how the petitioner will be entangled under section 109 for a property which was purchased by her mother and gifted in 2012, my lord.
So far as gift is concerned, your lordship page 40.
You know, I've seen it. I've seen it.
She has stated that 40 টা দেখুন, চার্জ শিট।
I've seen it. Anything else? Yes.
সেটা কভার করতে পারি তাহলে স্যার।
No, only thing, my lord, only thing your lordship is to consider the property which is been included in the asset, my lord. Whether it originally belonged to the petitioner or her husband. It was originally belonged to her mother. In 1996, she has purchased. In 2012, she has gifted the property.
Order is there. Order is there. Next.
I don't put one.
One.
And only, my lord, I will give that Dimple Jadhav.
And underline which part? Please.
And I'll give a short note, my lord, by tomorrow.
Not short note.
Not.
He will give.
Yes.
He has to give the Dimple Yadav. She is covered by Dimple Yadav, then I will. Please do that.
ଆଜ୍ଞା କାଲି ଦେଇଦେବି
ଆଜି ବି ଦେଇ
ଆଜି ଆଉ କେତେବେଳେ ଆଜ୍ଞା
no problem. Yes.
121, there are 3 cases tagged together. I am there in I am there in 3566.
All right for you, no problem.
Yes.
Rituals over.
Yes. I am highly obliged.
He lost his mother. He was not.
ଏଥିରେ 3ଟା କେସ୍ ଅଛି ବଡ ବଡ ସାର୍ ମାନେ ଅଛନ୍ତି I think it will take time for hearing.
नहीं तमे से petition मते टैग करनी
ऐसे ଗୋଟେ କେସ୍ ରେ ଆସିଛି ଗୋଟା ପ୍ରୋବ୍ଲେମ
अरे गोटे एफआईआर 3टा
ଏଣ୍ଟ୍ରି order is there.
Cognizance has been taken against 10 accused
He is
persons.
only addressing you, sir.
there are 3 cases.
if your lordship will go against me, my lord, your lordship will give it, then my lord liberty be given that.
Why do you presume everything?
There are 3 cases.
That is always there. Don't worry.
2 is being done by BS Tripathi.
Yes.
I am in 3566. There are 3 accused persons.
Yes.
Though one FIR, there are 3 accused persons in this case. They have been arraigned at different times as accused. So they are placed in 3 different footings, and their overt act and criminality will be different from each other. So BS Tripathi is insisting that his case should be heard. What I pray is that my case may be segregated, and I think Mr. Mahana will agree that I stand in
Arising out of the same FIR.
Same FIR, cognizance has been taken in a day against 10 accused persons. My learned senior is for 1, my learned friend is for 2, and all other 7 persons have not questioned.
But this short point in this case is that in my case, company has not been made a party. How can the company, without company being made a party?
That is a legal issue. How will you proceed? In the absence of the company being an accused,
so perhaps
in the offences under that, what is that offences?
NLPR Act.
NLPR Act.
Offense under section 13(2) read with 13(1)(d) of the PC Act 379, 467, 468, 471, 409, 120B of the IPC. MMDR Act 999. 120B of the IPC. Offences are there. So the thing is that, so far as my Lawrence Senior's case is concerned, that there the petitioner was the managing director. And the question of law is concerned whether without adding the accused as a party, the ground is twofold. One is company or partnership has not been added as an accused, and there is no specific allegation against the petitioner alleged or commission of alleged offense. So far as second part is concerned, that is there. It's a matter of trial, I do not. So far as first part is concerned, company is concerned, admittedly company has not been made as party. So far one case is concerned, that is 3114 something. Say case there is a partnership firm, and petitioner was the partner, and he was managing the affairs of the business.
Now, all are IPC offences.
PC Act offenses.
Prevention of corruption.
PC Act offenses there. So thing is that I have given certain judgment. So far a firm is concerned and partner is concerned, they can be. If he is managing the affairs of the company, he will be liable.
Right.
So far now they are taking the plea on the ground that relying the judgment, that doctrine of corporate veil. That principle नहीं company की party न करी की company liable होगा, person liable होगा नहीं. That is the principle basing upon the doctrine of corporate veil. That veil will be lifted, your lordship knows, under certain circumstances, if the person particularly without the knowledge of the company committed an offense, then he will be held liable.
Right.
Then another aspect is, suppose a company has not been made a party. That does not mean an accused will take the benefit that a company has not been made a party and I will be exonerated. Company can be added and accused at any stage under section 319 during trial also. That is my sole ground of it.
There is, your whole ground is, there is no legal bar in taking cognizance of an individual
My lord.
without there being a company also.
Also, even if during course of trial it comes to evidence comes,
319
they
BPM,
add it. And so far as vicarious liability part is concerned, so far criminal law is concerned and PC Act is concerned, vicarious liability will not be applicable. I have prepared a note. I have to make such correction. I will file it. The Lord's may dispose of it.
Yes, sir.
We have already filed a short note along with the judgment. It has been heard, my lord. That is, I am in criminal miss case number 3566 of 2016, where admittedly the company has not been made a party. Now your lordship.
And what are the points in other two matters?
Other two matters that company ହେଇନାହାନ୍ତି କିନ୍ତୁ more E114 of 2018 ଯୋଉଟା concern, they are a partnership firm. You are the managing the affairs. The partner who has affairs, so he will have life.
Stand in a
And other ସାରଙ୍କର ଆଉ ଅନ୍ୟ ଯୋଉ ଦିଟା କେସ୍ ଅଛି ସେଥିରେ ବି my stand is also will be that same. And I have given the note in different cases. In 3 notes ଦଉଛି ଯାହା କରିବେ।
Yes.
ସରିଯିବ।
Yes.
ନା ସିଏ ତ ନାହିଁ ନା।
ସେଥିପାଇଁ ମୁଁ କହୁଥିଲି। କାରଣ ଆପଣ ଦେଇ ଦିଅନ୍ତୁ ଆମର।
Shall I reserve it?
Yes, my lord. But I only want to point out 2-3 things. I have the cognizance. I have arraigned in as an accused after 4 years of the cause of action. Then, my lord, allegation in the charge sheet, I have got given a written note. Your lordship may kindly peruse it.
Not sufficient.
Yes.
Yes.
You got a written note.
Yes, it's there. I have that.
Short note of submission filed on behalf of the petitioner. Paragraph 5, my lord, your lordship may kindly see. Charge sheet allegation. I have quoted, my lord. Investigation revealed that F. Sirajuddin Exports Private Limited is a registered company dealing with export of iron ore from Paradip Port, incorporated under the Companies Act 1956, having its corporate identity number such and such, and its address is here. The director of the said company are Siraj Isha, Mayapalli Bhubaneswar, and others. I am Siraj Isha. Investigation revealed that during the month of March 2010, the company had received iron ore fines of 39.220 metric tons from Scan Steel Limited by transit pass number from Messrs. Scan Steel Limited by transit pass number which was issued on 18/3/2010 and also received 40.220 metric tons of iron ore from Scan Steels. Yeah, very interestingly, Scan Steel, which is supplying the materials, and on the basis of it is another thing, defense thing that I have entered into an agreement with the company. Scan Steel was the transporter, so that company has sent me the goods for value. That is altogether different thing. That would be a matter of trial, my lord. I am not going there. Lord, your lordship, the entire case is that I have received the material from Scan Steel by way of transport, my lord. Scan Steel has not been made an accused in this case.
Yes.
Then my submission, humble submission before your lordship is that in absence of the Scan Steel, who is said to have done certain acts of omission and commission, no charge can be framed against me.
Right.
That is one.
It is only cognizance has been taken. Charge has not yet been framed. Yes.
So, when initially they asked me to be a witness in this case. And because I was sent on behalf of the company, along with the documents. I was made an accused. I was an accused. Very strange, my lord. Finance transparency. During investigation, both the transit passes found to be forged as certain from the deputy director.
What are you? You are one of the
Right.
directors.
Huh?
You are one of the directors.
Yes, I am one of the directors. As ascertained from the deputy director, that such books bearing the aforementioned two transit pass were never issued to Mr. Standstill.
Yes.
Lord, first thing in the investigation would have been directed against the Standstill, where from you got this transit pass. Instead of that, my lord, your lordship, further the handwriting opinion has also been to Messrs. Further has been received that both the transit passes are false. Further, during exemption, N. Siraj, managing director of F. Sirajuddin Export, could not be able to produce any invoice of Messrs. Standstill showing sale of such quantity of them. The iron ores fines received through such false transit passes has been exported by the said company and thereby on. I have marked it, paragraph of the annexure 1 is the charge sheet, my lord.
Yes.
On the basis of the land special charge, the fact of the case is that Sirajuddin Exports, that is my company, has entered into a contract dated 27/1/2010 with JBS Energy Limited for purchase of iron ore for export. The iron ores to be delivered by JBS Energy Limited on FOR basis at G9 plot at Paradip Road from its sources. Annexure 3 at page 79.
Right.
So I had no direct dealings with this Standstill. Am I clear? I have a contract with JBS Energy Limited to purchase iron ore from them and they are to deliver it in my plot at Paradip.
Right.
As per the agreement, it was the obligation of the JBS supply of iron ore of grade as specified in the contract, which was to be transported by the truck engaged either by JBS Energy or its agent, submitting necessary permission copies, supply of iron ore. I have given annexure 4 is the contract, my lord.
Right.
JBS Energy Limited has raised tax invoices for the entire quantity to Messrs. F. Sirajuddin Exports Private, including the quantity mentioned in the first transit permit. But so they say that Standstill has not raised a invoice on you. But since I was purchasing from JBS Energy, Standstill is a stranger to me. Standstill might be acting as an agent of the JBS Energy. But JBS Energy has raised the invoice and I have paid the money.
Right.
The quantity received for the said transit permit has been duly certified by Messrs. JBS Energy Limited to the effect that it has been supplied by them. Accordingly, necessary invoice was raised by JBS Energy Limited and payment has been received. Annexure 6.
Right.
On 7/1/2020, the company received a notice. From here, my so-called connection with the case begins. The company received a notice under section 160 of the Code of Criminal Procedure, wherein during pendency of the inquiry, directed it to attend the inquiry. It as witness and the petitioner replied to the same. Then, because I replied, I become an accused. That there are 4 to 5 directors. I replied to this letter. There is no specific allegation against him that he is involved in the forgery of the documents, nor there is any evidence showing direct involvement of the petitioner, not from 161 statement or the documents received, my lord. I am not asking your lordship that to weigh the evidence at this stage, my lord. Your lordship, he has taken cognizance being prima facie satisfied. So your lordship is only to see whether on the basis of the charge sheet and the police papers, the documents relied on by them, and once
Any
it
case
was-
is made out or not?
the case is made out or not, involving me, because I am arrayed as individual, as accused,
Right.
involving my criminal liability as an individual.
Right.
Then Your Honor, I have given two decisions.
Yes.
These two decisions.
AR
Yes.
2021 Supreme Court 4587.
Yes, yes.
Ravindranath Dashpai.
Right. There are several in now, large number of cases also by Your Lordship, and
Sunil Bhatt.
this honorable court, if the company has not been involved, then the vicarious liability of mine will not arise. So this is all my case is, my lord.
Your written submission is very exhaustive.
And so far as the petitioner's point is concerned, they are at consigned point. They are supposed to keep the invoice and the transit pass, copy of the transit pass, whenever they are accepting the goods. So the transit pass,
You file your.
I am giving it. So Lordship,
file your.
सब तीन कैसे दे दो.
And insofar as the
other man say same.
FIR is same.
हाँ.
Other.
हाँ.
Yes.
तो फिर से मैंने कोई भी
Semana, let it be segregated. Otherwise, he will come and complain that why I have not. I wrote one.
I may be, pardon me, Lord.
Yes, Mr. Acharya is there.
I am for one of the accused persons in the sub-item number 3.
3, okay.
That is
Omi Bhagaya.
3157. Yeah, Milord, your lordship may. Bagadia. Milord, your
Yes.
lordship may kindly turn to page number 66. It is absolutely a case of no evidence. I am surprised. How can a Persian, Milord, I am a reputed exporter.
Page
I
61.
am one of page 66, Milord. This is
66.
the only
Yes.
portion I want to place, Milord. Your lordship may. Investigation revealed
Yes.
that Messrs. Bagadia Brothers is a private limited company having its registration number so and its head office at Bagadia Mission, ground floor, Jawahar Nagar, Raipur, Chhattisgarh. The directors of the company are Sri Umi Bagadia, son of Swanso, Om Prakash Agrawal, Prakash Raheja, Anand Agrawal, Anurag Agrawal. There are 5 directors. Why has he chosen me without making the company an accused also? I fail to understand. I think Mr. Mahanti was advancing that argument. If the company is not an accused in a criminal prosecution, there can't be any vicarious liability. Both Hayat Regency case, Bharti Mittal, Airtel case, Sip Jatia case, so many, Rane case, 3 judgments are there. You know, if that law is no more res integra on this issue, I'll come to that little later. The area manager of Bagadia Brothers is Sri Sanjay Bansal. He is the local representative. He is who was looking after the business. So let Jayaprakash Swanso telephone number, who is actually looking after the export of iron ore fines. Investigation revealed that the said company has received a quantity of 38 metric ton only. I might have exported not less than 3 lakhs of metric ton. 3 lakhs of metric ton. I am one of the reputed exporters of the country without paying heavy export duty to the country. Swanso, this is in respect of one truck, they say. Iron ore fines by transit pass bearing number Swanso 802. This is the document which they say that it is purportedly false.
Right.
A number Swanso. And the said quantity of iron ore was transported from TR Chemicals. Let your lordship kindly mark this.
Yes.
TR Chemicals is the consignor. I am the consignee. Under the relevant rules of the government of Orissa framed under this MMDR Act, section 15, the transit pass is to be applied by the seller, who is styled as consignor, to the respective competent authority, namely the DDM of mines.
he is to verify the form, he is to, my lord, deposit the challan, and the application is to be submitted as per Rule 10 of the Orissa Prevention of Theft, etc. Rules 2007. On being satisfied, my lord, the DDM is to issue the permit. My lord, the applicant is TR Chemicals. Granting authority is the DDM who has not been examined. So far, this particular transit pass is concerned.
Right.
I am the, my lord, consignee. Material was, my lord, supplied to us by TR Chemicals. I am in no way connected with either applying for my permit, that is, my lord, issued in a statutory form called Form I. It's a public document. So that particular document, so far I am concerned, my lord, has not been this, nor neither I am the maker of the document, nor I am a signatory to the document, nor, my lord, in any way I am involved with the issuance of the document. So therefore, the question of forgery doesn't arise.
How do you answer
Unless,
this?
my lord, your 465, your lordship may kindly see IPC, the definition of forgery. Unless, my lord, 465, my lord, let me read answer your judgment. My lord, 465 of IPC. Let the definition of forgery. Your lordship may kindly.
Yes.
I 464. I'm sorry. Making of a false document. A person is said to make a false document or false electronic record who dishonestly or fraudulently makes, signs, seals, or executes a document or part of a document. This is the essential ingredient to constitute for making of a false document. If the document, my lord, your lordship may kindly mark this. This is the judgment of it. Justice in Sariang.
Yes.
I'm just citing one of the decisions. It is there in this respect. But the essential ingredient is this: the document should be made, signed, sealed, or executed by a particular person against whom the allegation of forgery is alleged. So, my lord, neither I am the applicant, nor I am in any way connected with the issuance of the permit, nor, my lord, I have any culpability so far this procurement is concerned. I am a director sitting in Raipur. Another person is looking after the business. My lord, the whole story they say, one of the trucks, it has a checkered history. It was purchased, sold, and seized by the OSFC, sold to another person in Section 29 proceeding. So like this, there are lots of transactions. So far, this one of the trucks, my lord, which is involved in the transportation is concerned. They say that because of this is a first truck, so anything which has been transported by this particular carrier is first. As you've got it. The essence of the, if your lordship would look at the background of this case, one of the trucks, they have given me a full description about the truck. The essence is the truck is a theft truck, or the truck has been illegally sold. So therefore, anything, any transaction or any transportation which has been carried out by this particular carrier or vehicle, so everything is first.
I am not.
I fail to understand because somebody.
I'll take 2 minutes.
Yes.
No,
Try to
that is
understand
the
what he
story,
says is, what he says is, he is somewhere else. The theft and everything has taken place here. And in the absence of the company being an accused, he is a director.
That's correct.
Staying somewhere else. His employee might have done it. How will you bring vicarious liability in the absence of the director?
That's correct.
Being implicated?
So if my lord,
and one of the, there are 5 directors, Millard. And there are 5, and Millard, there is nothing a single whisper how I am responsible for taking those, whether I took the decision or I am a party to all this transaction, or there is some kind of involvement so far these documents are, making of those documents are concerned. Nothing, Millard. Your lordship, I was reading page 66. Let me just place this much is the accusation, Millard, so far I am concerned. Your lordship, further only 3-4 lines are left.
Yes.
And the other chemicals to the said company at Paradipo. Sri
Where are
Sanjay
you reading?
Bansal.
You are reading
page 66. Page 66,
yes.
Millard. I have read half of it, the paragraph. Half is left. But in the second para.
Yes.
iron ore finds by transit pass bearing number so and so, and the said quantity of iron ore was transported from TR Chemicals Limited. He is the Millard seller. I am the user end Millard at Paradip Port. He delivered the property to us. That is only in respect of one truck. Millard, the permit is for 2000 metric ton in this consignment. Millard, the balance 1932 they don't say, or 62 minus this 38 is not theft or anything, Millard. One of the trucks, Millard, they say, because this truck has a checkered carrier, so therefore the property is also stolen, they say. That is the logic which they have, Millard. That is the prosecution case. Millard, you will see Barpali to the said company at Paradip Port. This was procured from Barpali to the said company. This TR Chemi, it is a byproduct of that company, Millard. They sold it to the said company, and Paradip Port Sri Sanjay Kumar Bansal failed to produce any invoice showing purchase of such quantity from TR Chemicals. But the record of their stevedores clearly shows that a quantity of so and so metric ton was unloaded by them at Paradip Port, which was subsequently exported. This is a very fraction of the entire export quantity, Millard. In a ship, when we are Millard exporting, it is more than 10,000 metric ton at a time.
It is 38 metric ton.
38 metric ton, one truckload, Millard. Millard, why should a reputed exporter like me, I fail to understand, Millard, what is the logic and rationale behind this? 30 iron ore finds was uploaded by them, which was subsequently the deputy director during investigation clearly stated that no such, Millard, the deputy director has not been examined. Neither this particular document has been seized, nor, Millard, in either way I am connected with the preparation or making of this document so as to attract the ingredients of 464 to make me liable for the forging of the document and to use it subsequently for any valuable security. And so far the theft is concerned, Millard, it is absolutely, there is no element. Neither there is any mens rea nor no element. So, Millard, these two judgments I'll place, I have made a compilation, Millard. So this is the acquisition so far I am concerned. There are 5 directors.
You must give a written submission.
Millard, I'll give you a written submission. I'll give you a written submission. Millard, this is the case. Your Lordship may kindly look at the first page, the gist of the case in the charge sheet. Millard, page, it begins from page 61, 63, Millard. No, 61 minute, Millard. Begins from page 68, Millard. Sorry, 58, Millard. I'm sorry.
58.
Your Lordship may kindly, yes. Page 58, Millard, they narrate the prosecution story. Millard, I think 4-5 pages they have said about the history of this truck, this particular truck who is the carrier. So the logic which they have deduced from this theft truck is that because this truck is itself is illegally purchased or sold to some person who is not the bona fide owner, so therefore the entire cargo which was transported by means of this truck is forged. This is the logic. Millard, your Lordship, I don't want to waste your Lordship's precious time to go through all this, but your Lordship, kindly investigation revealed one Srimati Santilata Behera so and so purchased a truck 10-wheeler by HP so and so. This is the history of the truck, Millard. For how many price it was sold, how the OSFC seized it, and how it was sold to 3-4 persons, how the ownership was transferred here and there. Like this, Millard, they have given a description up to page 61, Millard. It is evident that Sri Behera last, Millard, page 61 bottom, above the table, you will see in the traffic, it is evident Behera contacted Sri Dhaneshwar Naik, traffic inspector and so over his telephone. After taking the vehicle from the garage of Sri Chagala Behera, Sri Patra, in connivance with Sri Dhaneshwar Naik, illegally engaged the truck in transportation. This is how they say that because this truck is the carrier, so therefore the entire cargo which has been carried by this particular truck is also, Millard, illegal. This is how they have derived.
Yes,
this is what the prosecution case is, Millard.
Yes.
But I fail to understand how it can be the truck may be prosecuted, but how can the others be prosecuted without any material to show that this particular...
Kindly have a
How
glance
will
to my
you
notes.
explain the point of vicarious liability?
The Lordship, kindly see my notes.
Your Lordship, page, I have given it.
No, for the purpose of 464, vicarious liability, unless personally they are involved.
He is the beneficiary. The company is the beneficiary. Because the stolen materials, iron ores, has been received by the company of the petitioner. And your Lordship, kindly have a glance.
Now you heard the new case of Kejriwal. The court said that
I have gone through that.
How can you prosecute the same situation here?
No, then your Lordship, kindly space 3, para 3.
The beneficiary is the company.
My lord, company is the beneficiary.
Without company being an accused, how will you bring vicarious?
No, he was the director. And your Lordship, kindly see. I have also.
Is it your case that the director is directly involved?
No.
For the purpose
No,
of
my submission is not that. Your Lordship, kindly see. Without hearing me, he's making that submission.
Yes.
Thing is that the one Sanjay Bansal, he was the director along with other director person. The Sanjay Bansal was the area manager who was managing all the affairs of the company. He will be liable. I cannot consider him this way.
Make wrong submissions. I'm sorry to interrupt. Sanjay Bansal is not a director. Please don't make wrong submissions.
Omi Bagadia. He's talking about Omi Bagadia.
Omi Bagadia was the director of the company. And Sanjay Bansal was the area manager who was managing all the affairs.
He is only arguing for Omi Bagadia.
Omi Bagadia. I'm giving that. I have given that note.
Vis-a-vis Omi Bagadia, you tell.
So far as my submission, my Lord Senior is concerned, that the false talk is that is the ground. No, the false talk is false, and the transit pass used for the purpose of transporting that was also false, and the DDM was also examined. The submission that he was not examined, that is not correct. Another aspect.
No, everything is accepted. Everything is correct.
My lord.
But where was the Bagadia? Yes.
He was the director, and on that count,
he Raipur, he was not directly involved. He was not directly.
Thing is that the company should have kept. He was the consignee point, and he is supposed to keep the invoices and transit passes. And the transit passes could not be produced, and on verification was found that as a false. That's why it was not produced by the company. And ultimately, the company was managing by the area manager from Bansal. And he will be held liable. I cannot consider in this way that Omi Bagadia will be exonerated. Can I say like this in this way? Then Omi Bagadia role nahi.
Then that's what he is arguing.
Same with the court even if in the court case, my honest senior was arguing, company, even if company is not made a party, can it preclude that others will go away and
the same treatment you should have given to them. If any evidence will come, you call them in 319. Why today?
Because
why today? There is nothing against these people.
Suppose there is some flaw in the investigation. Can on that count the proceeding will go?
Yes, today test is whatever material you have placed on the court, on the basis of that, whether prima facie case is made out of. If there is nothing against these people, where is the question of prima facie case? That's their whole argument.
The question is the company is that they are the director, and that hell will be lifted. My submission, they are relying the company should be made a party without making the company as a party. They cannot be made.
They say if company would have been there, the vicarious liability could have been traveled through the company to them. In the absence of company, the vicarious liability also can't travel to them. That is the case.
My respectful submission is if the question of vicarious liability will not come so far as PC Act offence is concerned, on IPC offences criminal conspiracy is concerned.
Who says?
That will not come. That is the judgment I have led. Your Lordship, kindly see my notes.
There is no element of PC Act at all. There is no. How does PC Act apply to us? I fail to understand. There is the question of
ସେ ଡାଇରେକ୍ଟର ଯାଇପାରନ୍ତି ମୋର ସେଥିରେ କିନ୍ତୁ ଯୋଉମାନେ ମ୍ୟାନେଜ କରୁଥିଲେ ଦେ ୱିଲ୍ ବି ଦେୟାର ସମସ୍ତେ ପଳେଇବେ ସେ ନୁହେଁ
then you consider that
କହିପାରିବିନି
attribute an overtake to the director. Among 5 directors, why should I be
There are 5 directors. Not only I am not the managing director, there are 5 directors. So why does he conveniently
Page 5,
pick up one?
State of
and say that
Maharashtra
you
was
are the
indicate
accused,
transport.
You have filed separate?
Separate.
Which one you are doing?
That is
Umi Bagadia.
3157 of the author.
Pitambar's case.
Madam.
Yes.
State of Maharashtra versus Syndicate Transport Corporation Limited and others reported aired 1964. The question whether a corporate body should or should not be liable for criminal action resulting from the act of some individual must depend on the nature of the offense disclosed by the allegation in the complaint or in the charge sheet, the relative position of the officer or the agent vis-a-vis the corporate body, and the other relevant facts and circumstances which would show that the corporate body as such meant or intended to commit the act. Then, State of Karnataka Jayalalitha case. It was finally held that the concept of corporate entity was evolved to
Again, you are bringing that corporate bail issue.
that is
It should be lifted or not lifted. That's not the issue here.
Then another judgment. Para 5. It would travesty of justice if the big business houses like Swarna Modi Industries Limited is allowed to defeat the prosecution launched and avoid the trial on the technical.
Let's imagine and factually just see that Omi Bagadia.
He was not there.
He was not there. 38 metric ton of iron ore.
One
And
truck.
he
He lacks of benefit on that I have exported that particular year. Why
The
should I
question is
steal?
not if some transit pass they are using and they are supposed to keep the transit pass because they are the consignee.
is not
Admittedly,
my duty.
Sanjay Bansal was managing the same. He should have kept there.
Yes.
My respectful submission is I cannot make that submission. So, but director is concerned, you will not be held liable.
You catch hold of big fish, then you get.
But he's fair enough.
No.
He's
ସେଥିପାଇଁ ମୋ
fair
କହିବା
enough.
କଥା
He
ଯେ
says
ଅନ୍ୟ ଯୋଉମାନେ
director
those
is not
are
liable.
actually involved in managing the affairs, they will be held liable. Like the Sanjay Bansal.
They are. There is no doubt about it.
Fair enough. Fair enough. Fair enough. But he says that the director is not liable. You are not simply recording. Very fair. Very fair.
Page 92, you have accepted.
92.
Is the notice
Yes.
to the managing director to FC Rajuddin Exports Private Limited. I, as a director, was interested in the responsibility of giving a reply, and my reply.
You were called as a witness, basically.
I was called as a witness.
ସେ director ଅଛି director ଙ୍କର ହବ ଅନ୍ୟମାନଙ୍କର ହବ
Here, Lordship will see page 96. The description is that I am a director. So, because I have given the reply, I have been added, he styles me as managing director.
Either in my case, neither I have examined, nor they have visited my
Shall I
office.
reserve or you want some time once again to be heard?
ସେ ଆଉ ଗୋଟେ କେସ୍ ଅଛି ସେ ପରେ ଆସିକି କହିବେ ଯେ କରନ୍ତୁ ତେଣୁ ମୁଁ ନୋଟ୍ସ ଦେଇ ଦେଇଛି ତ ଲର୍ଡସିପ
Sir, ସରିଲା ଏତିକି case ଆଉ।
ସେଇଟା ତାର ଅଲଗା ପାର୍ଟନରସିପ
ପାର୍ଟନରସିପ ଫାର୍ମ ସେଟା ଯୋଉଟା ସେଟା ପାର୍ଟନରସିପ ଫାର୍ମ ହି ୱାଜ ମ୍ୟାନେଜିଂ ଦ ଆଫେୟାର୍ସ ସୋ ଦ୍ୟାଟ
Partnership form yes.
ଲର୍ଡସିପ ନାହିଁ because I do not ମୁଁ ସେଇଥିପାଇଁ
ଆମର ହଉଛି JBS
ଛାତି ରଖିଦିଅ।
JBS
Milord, so far mine is concerned, let it be resolved. It's so far, Milord, so far.
Maybe
the
pardon,
third
item
item,
53
let it be resolved, I
place
will take a
admission.
note.
Let it be admitted after conviction.
Appeal.
53.
53 appeal.
Appeal.
Criminal appeal.
Let it be admitted.
Admitted. 53.
53.
Sentence?
53.
Sentence?
Sentence 2 years.
2 years.
Array for 3 years and array for 1 year.
He's in custody or what? No. 389 benefit might have been. Okay.
I have given in all.
And fine to be stayed.
May I pre-eminent item 30?
And a free copy be given.
Milord, the interim order, Milord, one second.
He was called,
Interim order
but I was not because
I saw you were there.
Yes, but I was called by in court number 1 in NSA case.
2 o'clock.
2 o'clock, but the case is continuing.
ସେଟା ଆଉ ଦିନେ ଆସୁ ଗୁଡାଏ କେସ୍ ତା ଦେହରେ ଅଛି ଟ୍ୟାଗ ହେଇକି ଆସୁ ହଁ ଟ୍ୟାଗ ହେଇକି
ଓକିଲଟା
ହଁ ଓକିଲ ତ ପଇସା ଖାଇଛି ତ କଣ କରିବେ
ମାନେ
End of the board will try.
Yes.
End of the board.
End of the board
ତିନିଟା ବେଳେ
ଆସିବ କିଛି ନାହିଁ ଏଥିରେ ଆମେ କ୍ଲାରିଫାଏ ସେଥିରେ PIL ଫାଇଲ ହେଇଛି in pursuant direction of Disproportionate court investigation was taken up ତେଣୁ Cognizance ନିଆଯାଇଛି ତେଣୁ ଆହୁରି ମଧ୍ୟ ସେ କ୍ୱାସିଂ ପାଇଁ CRLP ଫାଇଲ କରିଛନ୍ତି ସବୁ ଗୁଡା ଆସୁଛି ହଁ CRLP ପୁରା ଫାଇଲ ହେଇଛି
investigation
FIR କ୍ୱାସିଂ ପାଇଁ ଅଛି ବର୍ତ୍ତମାନ
here is a case like this. Now let me say if an admitted has submitted, I'm saying
petitioner before my lord was additional public prosecutor Baleshwar. He was entrusted by collector to do some works in settlement this time because of his integrity, because he is there since last 15-20 years. Another lawyer who was interested to be additional public prosecutor, he filed a petition before the collector. Collector conducted an inquiry, made an inquiry, and gave a clean sheet to the petitioner. Again, he drew the attention of Lokayukt. Lokayukt had sent it to Law Secretary. My Honorable Justice Mishra was the Law Secretary during that period. He had made an exhaustive inquiry and also given a clean sheet. He filed a writ application before this Honorable Court, making Lokayukt and Law Secretary as a party here. The writ is still pending here. While the situation was such, he filed a complaint petition. And that's because, filed a ballot SCRLMP, why investigation is not being carried about vigilance. So I draw the attention of the Honorable Court filing a CRLMP, all documents that the investigation be quashed. That was pending. Investigation has been completed because time and again he forced the vigilance people to file charge sheet. And accordingly,
informant in this case?
A lawyer, my brother, yes.
Who was aspiring to become?
Yes. Since last 20 years, I am there because of my goodwill, because of my
documentary evidence is there.
Documentary.
We conducted inquiry.
I will draw one line, my lord can see. I have folded it to show my lord. My lord, we see paragraph.
55, na?
My lord.
30. 30. 38, na?
38 is my item.
So, how desperate a lawyer can be against a brother friend, my lord.
What is the stage now?
Sojati Paramahan.
What is the stage?
Stage, my lord, cognizance has been taken.
Cognizance taken.
I'll stay the
No, stay proceeding, stay. Your lordship can.
And fight between two lawyer friends.
Lawyer friend, in pursuance to your lordship can visualize.
My lord, may see.
Division bench, PIL is pending.
May see.
Lokayukt order is under challenge.
My lord, may see.
Time, I'll tell you, time will heal everything.
No. Thing is that.
My lord, may see. My lord, may see. Page 109. Page 109.
109. 109.
Look,
what are the offenses?
Offenses under section.
Offenses under
section.
On the face of two inquiry, exonerating.
No, two inquiry in what? Not that two inquiry.
Violent may see the report of 109, the report of Lokayukt, considering the report of collector 109. I have quoted that.
Yes.
It is seen. I am not reading it because violent may see.
At best, he can file a petition for adjournment.
It is seen. Violent may 109.
So and so principal secretary.
The law department functioning as honorable
Yes.
That is the report of Lokayukt. After careful examining the inquiry report has rightly declined to take an action to a complaint of the complainant. Even before us, the complainant has not filed any material which may persuade us from taking a different view. Also, no material has been placed before us to suggest that any favoritism has been shown by so and so, my lord.
So and so.
My case Sudarshan Chakravarti, Sri Sambit Kumar Naik, Sri so and so Das. Therefore, in the absence of any materials, allegations, corruption cannot be presumed against the officers. The complainant has to.
Offense under section 13(1)(c), D, 468, 471, 120B, 109. Thing is that in pursuant to direction of this
these type of persons are increasing the society, and what they are doing, they are getting everything on RTI and blackmailing, so to say.
RTI re hele kon documentary evidence guda RTI re theory kara hai jitki. Thing is that we conducted investigation in pursuant to direction of dishonorable court. Dishonorable court. He is a lawyer, I do admit. Thing is that we conducted investigation in pursuant to direction of dishonorable court.
What are the offenses again?
And another case is pending.
Cognizance order.
13(1)(c) of the PC Act, 468, 471, 120B, 109. So at best he can file a petition under for adjournment. Stay cannot be, PC Act offense, stay cannot be. And so far as other cases are still pending, they challenge the proceeding. That is pending. Court pending ଅଛି how and you are not-
Investigation को challenge करा रहा है. Is that it automatically merged with this?
And what will happen to that division bench case?
That petition has become infructuous.
Infructuous automatically.
Super as PL
Take up opposition, Mr. Paradise.
ନାଇଁ opposition ନାଇଁ ମୁଁ ତ କହୁଛି ଏଟା ସବୁ ଯାକ ଆସିବ କାହିଁକି because without going through that
ଆସୁ ସବୁ ଜାଗା ଆସୁ.
PL is pending, division bench is sitting over the matter.
Who has filed the PIL?
ତାଙ୍କର କିଏ ଫାଇଲ କରିଛନ୍ତି ମୁଁ I don't know. Dishonorable court
Say liar.
dishonorable court entertain directed to ye to file affidavit.
One lawyer friend is after the life of other, and they're using you. They're using you to take revenge against you.
More thing is that we did not register. We did not conducted inquiry. Dishonorable court directed to conduct inquiry. We pursue the inquiry in pursuant to direction. Law is well settled when the investigation is taken up in pursuant to direction of this honorable court. It cannot be said that the investigation is malafide.
Where is that order?
ସେତେବେଳେ CRLMP order ସେଥିପାଇଁ କହିଲି CRLMP ସବୁ ଯାକ ମିଶିକି ଆସୁ.
Don't you have that order?
ନା
by which
ସେମାନେ ଦେଇନାହାନ୍ତି ସେଗୁଡ଼ା ଦେଇନାହାନ୍ତି.
give a direction?
ସେଗୁଡ଼ା ଦେଇନି ଆପଣ ମୁଁ ଦେଇ ଦଉଛି ଗୁଡ଼ାଏ କେସ୍ ସେଟା ସବୁ ଯାକ
ରେଫର କରିଛି ମୁଁ କନଷ୍ଟାଣ୍ଟଲି.
ହଁ ସେଗୁଡ଼ା ସବୁ ଯାକ
ମୁଁ କରି ନାହିଁ କିଛି.
it will be better. ସେ ଯାଉ ରହିବ
But
ମୋର
it is
ସେଥିରେ
listed before some other bench. How can I get?
Not assigned to the.
I can't get to that.
CRLP assigned to other bench.
ଯୋଉ କୋର୍ଟ ଦେଇଥିଲେ ଡାଇରେକ୍ସନ ସେ ଶୁଣନ୍ତୁ ଯେ ଥିବେ ନହେଲେ ଅନ୍ୟ ମୁଁ ସେଥିରେ କିଛି କହିବାର ନାହିଁ. କିନ୍ତୁ thing is that it at best he can file a petition for adjournment.
Let me adjourn it. Yes, adjourn it. I will file an application for
adjournment. That will be better.
Oh, bunda pit diya na.
State of Vishak
notice to the opposite party, Mr. Marana accept notice. In the meantime, the petitioner may move an application for the court below seeking an adjournment, adjournment owing to the fact that the matter is subject before the court. If such application is moved, you can submit it.
Maybe pardoned, Your Lordship.
Time, I tell you, these are the matters. Time will heal.
ମୁଁ ବସ୍ ସେଇ କଥା କହୁଛି ଯେ ଆପଣ ଏଥିରେ
Two lawyers, let it be.
may I submit my lord?
Storage, everything will be taken care of.
ଆଜ୍ଞା CRLMP ରେ ରେଜିଷ୍ଟ୍ରେସନ ନ କଲା ବେଳକୁ କରୁନାହାନ୍ତି. CRLMP ରେ ରେଜିଷ୍ଟ୍ରେସନ ନ କଲା ବେଳକୁ ଇନକ୍ୱାରି ନ କଲା ବେଳକୁ କରୁନାହାନ୍ତି ଏବଂ କହୁଛନ୍ତି ପର୍ସନାଲ ଆପିୟରାନ୍ସ ଅଫ ଡାଇରେକ୍ଟର. କଣ what will say?
Making allegation against one of the finest gentlemen you have around you.
And he is opposite party number.
And that goes to show what kind of man he is.
Opposite party number 3 is the writ application.
Thing is that so far as the petitioner is concerned,
he has been very fast.
He has arrayed him as an opposite party number 3 in the writ application. And how it is a public interest? I don't know.
ଆପଣ ଆସିଲେ ତ ଦେଖିବି କାରଣ ମୁଁ I was conducting dishonorable court not trying to interfere.
You kindly show me the order by which the
ସେଟା CRLP ସେଥିପାଇଁ କହିଲେ CRLP ଆସିଏ ତ ଦେଇ ନାହାନ୍ତି.
It is a division bench order. Is it a division bench order?
No, single bench order.
Single bench ରେ CRLP ରେ direction ଦେଲେ
My Lord Justice
PIL pending ଅଛି.
Directing to
Get that order. This order will stay, but I'll take it up at 3:30. I want to know this.
ମୋ ପାଖରେ ମୁଁ କରିବାକୁ ପଡିବ.
Get that order.
ନା ଅର୍ଡର ଟା ସେଟା ଅପଲୋଡ କରିଦେଇ ପାରିବେ ଆଉ ଡିଭିଜନ ବେଞ୍ଚ PIL ରେ କଣ ପୋଜିସନ ସେଟା ଦେଖିବାକୁ ପଡିବ.
No, let us.
I will provide it.
Let us put a quietus to the attack. Nothing.
କାହିଁ କହୁଛି let it come after vacation. He is enjoying the interim protection your lordship granting. I have to file a reply. Your lordship visualize my predicament also. I have to file a reply.
Let him file the reply. Yes, sir. And if such application is made, the same shall be considered favorably.
So that my case
ସେଥିରେ ତିନିଟା ଆଙ୍କରେ ମୁଁ ଦେଇଦେଇଛି ତିନିଟା ଆଙ୍କରେ ଇଏ କଲେ ବର୍ଷ.
My Lord, I may be pardoned. My Lord, item 38 Passover. My Lord, item 38 Passover. Kindly, it has been adjourned in advocate.
Just take it up immediately.
Grateful, Your Lordship. Extremely grateful, my Lord. Item 38.
the learned state counsel, they are okay with me placing the matter after the compromise matters, my lord.
What is the urgency?
My lord, the urgency is that I had filed a 205 application before the learned court below. The learned court below has rejected that, my lord. So I have filed a CRL.
Great urgency can be.
My lord, it can be just disposed of. Just one decision that even on the first date of appearance, relying on Punit Dalmia's case, that can be disposed of also, that I can appear through my counsel. That is the only small prayer.
That is not the condition.
I'm willing to obey by any conditions, my lord.
There is
That is
no
not-
opposition to.
Your lordship may call the matter after the compromise matters. I'm gratefully, lordship.
But the
Check that judgment.
again, no, with the judgment or with the statute, 207 and 238, it is very clear. He has to comply that. Then thereafter, this
Subject to compliance.
My lord, may kindly,
Unless
my lord,
this-
my lord, permit me to place this judgment.
this judgment is no way. my lord.
I'll establish. My lord, may kindly call the matter.
After compromise matter.
After compromise matter,
Again,
lordship,
again.
I'm gratefully, lordship.
Again.
Yes.
28.
20. Yes.
My lord, item number 28. My lord, the petitioner before your lordship to quash the inquiry and consequential criminal proceeding
Yes.
initiated against the petitioner in pursuant to saw dated 22 November 2017 on the allegation of the possession of DA by the Cuttack Vigilance cell minutes. The search was conducted, my lord, in the year 2017, and in the meantime, my lord, 7 years has been already elapsed, and no FIR has been lodged against the petitioner,
So far as
and the inquiry has not been.
so far as instruction received, said that we conducted inquiry in pursuant to search, and no DA case has been registered against her, as no offence under disproportionate asset was made.
My lord,
What do you want?
my lord, the thing is that.
Observe that and I dispose of.
My lord, the thing is that lordship may dispose of this case with the opposite observation, my lord.
That's what I
Because they will harass again and again, my lords.
When the inquiry started?
2000 on search was on 22/11/2017.
22/11/2017, my lord.
Pursuant to a search conducted by the department on
22/11/2017.
22/11/2017.
Filed Miss case number 12/2017.
12/2017. A preliminary inquiry was conducted. Although the preliminary inquiry has been going on since 2017, no regular case, no regular FIR was registered here. Mr. Maharana, on instruction, submits that
No DA case has been registered against the petitioner, as no such offence could be, so for possession of disproportionate asset could be established during inquiry.
could be established in view of the aforementioned statement made in the bar by the counsel for the vigilance. The petition, no interference is called for in the petition, and the criminal initiated criminal law set into motion against the petitioner has already been dropped according to the petition.
Dropped in respect of a DA. The out case on your case,
In respect of DA.
Possession of a DA. Your lordship, instruction number 2144 dated 15/5/24.
Instruction dated 2144 15/5.
15/5/24.
Very important, right? No?
My lord, my one request, my lord. My full name may be reflected in the order sheet, my lord. My full name may be reflected in the order sheet, my lord.
Full name.
Full lordship.
Yes. 43.
Well, in this case, the petitioner has prayed for the passment of the FIR source of the criminal proceeding, and the victim and the opposite party number 2 is the victim and the informant. In the meanwhile, they have prepared a joint affidavit and produced before the Sonu court. In para 2 of that joint affidavit, they have said that they will remain separate, that they will not destroy all the evidence of intimacy and everything. And in pursuant to that, the petitioner has destroyed all the evidence, and only remaining pen drive manner he is producing before the Supreme Court. On the last occasion, the lordship had directed.
This is the pen drive. Where is the girl?
Girl is my lord.
Page 23, wherein my 205 application has been rejected.
Yes.
My lord, may kindly see the impugned order at page 23, the second paragraph. Heard, no, but the first paragraph also. The case record is put up today for the petition for order on a petition filed by learned counsel for the accused Minalata Malik under section 205 of CRPC, praying therein to exempt the accused person from appearing in person at the subsequent stage of hearing on the ground stated therein in the petition, and in view thereof, the accused may kindly be permitted to appear through her advocate under 205 of CRPC.
What is the offense?
My lord, the offences your lordship will see at page 6.
Tell me the offense.
My lord, charged under sections 417, 418, 468, 464 and 471 IPC. This is the father-in-law who has lodged a complaint against the daughter-in-law after the marital discord between the husband and the daughter-in-law, and thereafter when the girl has instituted complaints against the husband, the father-in-law and other members, thereafter, my lord, this FIR has been registered. The FIR states that there was an agreement, a partnership agreement between the daughter-in-law and father-in-law over a plot of land which was to be managed for getting, your lordship, a petrol pump.
Father-in-law is the complaint.
Yes, your lordship. Files a complaint case that is then registered, and subsequently investigation carried on, and thereafter this has come up. And thereafter there is a marital discord going on, and there are n number of petitions pending before this honorable court, transfer petitions and other petitions between the family members of the wife and with these, I'm saying in Bhadrak, my lord, more than 460 kilometers away.
Yes, Mr. Kumar.
You also may kindly see page 23 for us. Last
20?
23.
Yes.
Last part. Just got it?
Yes.
Sentence starts from as the present case. As the present is a warrant trial case, therefore the accused person has to appear in court and cannot claim exemption of 205 of CRPC till they have furnished bonds with or without surety as per the direction of this court. Therefore, in the present fact and circumstances, the gravity of the offences, I am not inclined to reject. So 207 and 238 of CRPC, it has to first comply. Then you can avail all the benefits.
My lord,
available under law. Unless until
Have you got the bail?
no, my lord, I was never searched for. My lord, the honorable
My
lord, the honorable apex court says otherwise, your lordship. Okay.
Which para?
My lord, may kindly have page 700. It starts from paragraph 6. My lord, this is the judgment in Punit Dalmia, which has relied upon Bhaskar Industries, where the scope of 205, 307 powers the court to dispense with the personal attendance of the accused, provided he is represented by a counsel in that case, even for proceeding with further steps in the case. However, one precaution which the court should take in such a situation is that the said benefit need to be granted only to an accused who gives an undertaking to the satisfaction of the court that he would not dispute his identity as to the particular accused in the case, and that a counsel on his behalf would be present in court, and that he has no objection in taking evidence in his absence. This precaution is necessary for the further progress of the proceedings, including examination of witnesses. A question could legitimately be asked: what happens if the counsel engaged by the accused, whose personal appearance is dispensed with, does not appear, or that the counsel does not cooperate in the proceedings with the case? We may point out that the legislature has taken care of such eventualities. Section 2052 says that a magistrate can, in his discretion, direct the personal attendance of the accused at any stage of the proceedings. The first limb of section 317(1) confers a discretion on the magistrate to direct the personal attendance of the accused at any subsequent stage of the proceedings. He can even resort to other steps for enforcing.
That is what the trial court did it.
Your lordship, may kindly
2052.
Yes, my lord. So therefore, my lord, he can in case
court says that you come and file
No.
bond thereafter 3 years.
Your lordship, may kindly appreciate. My lord, what I'm saying is, even on
how could we overcome 238?
my lord, that is there in para 7 in the first paragraph. This eventuality comes into play once the lawyer does not cooperate with the proceedings. My lord, may kindly once again have paragraph 18, the starting point. A question could legitimately be asked, which might happen if the counsel engaged by the accused, whose personal appearance is dispensed with, does not appear, or that the counsel does not cooperate in the proceedings. That is where the honorable apex court answers that. So in that event, in that eventuality, the 2052 can be taken into account to direct the personal attendance of the accused. In this, my lord, this is a case of PC Act with other offences, but the Dalmia judgment, which I'm relying upon, Punit Dalmia, my lord, this is a case of PC Act along with other offences. Whereas in Dalmia, it was of much shorter offences, much lesser of graver offences. And thereafter, your lordship may kindly say what the honorable apex court says at paragraph 8. In view of the above and for the reasons stated above, and considering the facts and circumstances of the case, the present appeal is allowed. The impugned judgment and order passed by High Court as well as that of the learned court rejecting the application submitted by the appellant under section 205 are hereby quashed and set aside, and consequently the application submitted by the appellant to dispense with his personal with his appearance before the learned trial court on all dates of adjournments and permitting his counsel, Shri Bharadwaj, ready to appear on his behalf, is hereby allowed on the following conditions. And thereafter, my lord, conditions are imposed, which I had read to your lordship, that he will not dispute his identity and all of those things, your lordship. So therefore, your lordship, even on the first date of appearance on 205 application can be moved, and accordingly that should have been allowed. This would be my respectful submission, my lord.
Yes.
Now, my lord, section 238 is also made. When in any warrant case, like this is a warrant case. When in
238.
Yes, 238. Compliance with section 207. When in any warrant case instituted on a police report, the accused appears or is brought before a magistrate at the commencement of the trial, the magistrate shall satisfy himself that he has complied with the provision of section 207.
Yes.
এটা যদি আমি নক করি তাহলে 205 কেমতি তাহলে in all cases people will come and say that 205 no bail is required every case, because this is the same case 420 468 471, so everybody will come. Why 438? Everybody will come. 205 they will continue, no necessary for bail. That is why all submission process may consider.
My lord, all through during the trial, I was never required to be present. I have not been arrested. I have not been shown as an absconder either.
What is the ego? Then you go and furnish the bond. You will be granted bail. What is the big deal about it?
Your lordship, may I kindly observe that, my lord.
I'll do that.
Your lordship.
You go.
But my lord, my respectful submission would have been.
The court says that 317 is open to you. The court only says that you come and furnish the bond.
My lord, that once I'm given that direction of 317, my lord, it would be for each date, but 205 would be for all the time in future. That is why, my lord, my prayer. Your lordship may kindly appreciate, my lord, the distinction between 317 and 205. My lord, for each date.
It's all right, but you do one thing, you go in the first appearance, appear, then you move another application. Yes.
That your lordship may grant, and accordingly, your lordship may kindly consider. My lord, may
application in view of this judge.
I'm grateful, your lordship. So accordingly, my lord, that would be the case.
The petitioner is agreed by the order dated 3/4/2024 passed by which court? SDGM, huh?
Yes, my lord. SDGM, Sambalpur.
SDGM, Sambalpur. In DR case number 1783 of 2023, whereby the application of the petitioner under section 205 CRPC has been rejected. While rejecting the application, the court below entry stated is under read up page 23, last paragraph. As the present case is a warrant trial. It is not last. Last counsel for the petitioner submits that. No more res integra, that application under section 205 CRPC is maintainable at the threshold of the trial. In regard to buttress his argument, he is relying upon the judgment of the Supreme Court in reported in 2001 7 HCC 401 Bhaskar Industries Limited versus Vivani Lenin and apparels. He emphasized para 70, which reads 17 and 18, 17 and 18. Relying upon the aforesaid judgment, he says that the provisions of section 205 and 207, 370 operates in different field. Therefore, the trial court was not correct in rejecting the application. Mr. Maharaj appears for the stage and submits that in view of the provisions contained in
section 238 of
CRPC, the trial court has rightly rejected the application and directed the petitioner to appear and furnish bond to begin with. And thereafter, the trial court has given liberty to the petitioner to apply liberty to the petitioner to avail the remedy under section 317 CRPC. I find no reason to interfere in this matter. The petitioner should appear before the court below. When do you want to?
Not after
On or
vacations.
before 30, on or before the 30th May, 30th June 2024, and furnish bail bond as directed by the court below. Thereafter, he can revise his application under section 205 CRPC or under section 317 CRPC. Yeah. If such application is moved, the same shall be considered on its own. Once you appear,
My lord,
and relying upon the if such application is moved, the same shall be considered in the light of the judgment relied upon by learned counsel in so and so
in
supra.
Puneet Dalmia, my lord.
In Dalmia Supra.
That has been taken note of.
My lord, that was said that it is, does not apply.
I know that I have seen Puneet Dalmia. Is
Yes, my lord. My lord, Puneet Dalmia and the other judgment is
But
a
you are relying upon the Puneet Dalmia relied upon that judge.
Yes, your lordship. My lord, the law evolved from that, but 205, my lord, is no longer resenting. Even on the first date also, my lord, I can appear and I can move ahead. But as your lordship pleases, my lord.
But these are 205 is available in exceptional cases. That every accused is moving application.
My lord, she's staying, your lordship, may kindly appreciate.
In
My
your
lord,
case, it may be because
Yes.
you are a lady.
I'm a lady
and
staying
initiated by
for
your
40
father-in-law.
Yes, my lord.
You have a case. Right?
Yes, your
That
lordship.
is why.
I'm
That is why this long order.
I'm
Otherwise,
extremely
you would have
grateful. I'm so grateful, your lordship.
Item 40. Here the petition challenging proceeding on the ground that self-same issue, the issue has been resolved in a civil suit number 80 of 2017 before the London Civil Judge Keunjam. Actually, like this one, in the bank, the informant, a sanction 11 number of tractor loan in favor of various borrowers. Petitioner is one of the borrowers. Thereafter, it is detected that the documents which was produced, subsequently it is detected that it is false. Subsequently, the bank filed a civil suit in the year 2017, which was ended with a memorandum of settlement under Annex 3. Subsequently, as per the settlement, the petitioner paid entire amount. Thereafter, on 19/12/2023, suit was finally disposed of as compromise. So that is page 30.
Yes.
Page 30. Yes. Last part of the operating part. As the dispute has been wholly settled to the full satisfaction of the plaintiff, as submitted by the branch manager as well as the learned counsel for the plaintiff, and the plaintiff does not want to proceed further in this case, the suit is disposed of as withdrawn.
Yes.
Since you also enter, issue has been settled in a civil suit, and may not be of the person.
Yes, ma'am. But this is my a case where the
Who is the informant? Bank.
bank. But
You issue notice to bank.
that settlement absolutely not applicable to this case. The settlement is different. The case is different. The issue in between the bank and the customers, but that does not mean the question of applying the mind so far the forgery document are concerned. You see what is forgery document? They have deposited forgery document, pursuant to the forgery document, they have taken loan.
No, actually, the offense is inter se party. If they dispute, let us issue notice to bank. Let the bank come.
Say similar case, stay on the pending.
Issue notice to number 2. If the bank is satisfied, then we'll see what will happen.
Bank satisfied,
In that matter, the bank says that it will go on.
সে কিন্তু সেটেল করনাতে যে ক্রিমিনাল কেসরে সেটেল সে কি সে করতে পারিবেন সেটা মনিটারি ট্রানজাকশন কনসেপ্ট দে আর সেটেল দ্য ডিসপুট
See, it is not, it is a bank, it is again a policy decision. Who will take the call?
That's right.
The bank will say that civil dispute is over, but criminal case we can't say anything.
সেই তো কেসে আসলে
That's the
সেটা
difference.
কইলে
That's the
they
difference.
lost the issue notice
We'll issue notice, we don't know. Somebody may come and say, yes.
Yes, the tractor loan, man, this petitioner is farmer.
I know. Yes, next.
He does not know. I am IX.
Counsel for the
OP
petitioner.
number 2 is notice to OP number 2
I am made the part.
yes sir
Submit that we would move application before the court below seeking agreement, owing to the fact that the matter is subject to. Yes, next.
In another case, it has been tell, let's kind of further process.
Oh, no.
Let's
Further proceeding is dangerous. I gave that liberty to. Next. 41. We are moving very slow today.
In another case, it was stayed, my lord. That's what I am saying for.
All right, this is also tantamount to stay on. Yes.
Since in that case, it has been stayed. Therefore, I am praying.
No, nothing there.
Let's kindly consider.
Mr. Dalai, you must hold a glass of water.
Lordship, and
You are getting more.
Lordship, I'm extremely sorry for the event, Lordship.
And it is not expected. See, he is doing his job. Why unnecessary you are getting? This happened.
Lordship, but I am not add anything, Lordship, but I'm saying I'm extremely sorry. But
Anyway, it's all right.
Lordship.
No problem.
But I want to continue, Lordship.
Yes.
When I had stopped the Lordship.
I forgot and he also forgot.
Lordship, we have,
And you also forget.
Lordship.
Now you started fresh.
Lordship.
Yes.
Lordship, here, Lordship, kindly see. I'm raising a point, Lordship.
You are challenging the cognizance.
Order of cognizance.
Yes.
If a Lordship see that running page 46, it appears the London Court below has taken cognizance of the offences that is under section 420, 294, 5062, 34 of IPC, read of 3 of 1 and RS and 2VA of 5A of the SCST Act, bracket of PO Lordship Act is taken.
Right.
So, Lordship, mind Hamasha, here is a case. The London Court below has taken cognizance contrary to the charge sheet submitted by the investigating agency. And while submitting a charge sheet by the investigating agency, it has been clearly opined due to insufficient evidence, Lord, the case is requested to drop the case, Lordship. And in contrary to the findings of the investigating authority, the London Court below has taken a contrary view by taking cognizance of the aforesaid offences and has issued a notice summons to me, and I am that's why, Lordship, I am before Lordship.
Right.
At the threshold, Lordship, my humble submission, Lordship, kindly say what are the provision under 196, 190, Lordship. 190, Lordship, clearly speaks of, Lordship, the duty of the London Court below to take judicial notice of the offences. So at the same time, Lordship, the offences followed by the ingredients. My humble submission, if there is a report of the charge sheet investigating authority, due to lack of evidence, Lordship, insufficient evidence, he is requesting for drop the proceeding, London Court below must.
It's not binding.
No, I'm not on that, Lordship. If at all he is taking cognizance of the offences, his duty is to go through the offences whether the ingredients are available or not. That is the basic requirements law also, Lordship.
See, so show me the order then.
Lordship, then Lordship kindly come.
Order, I think order is very detailed and speaking order.
But Lordship,
And from a side, the court has arrived at a.
that is my only submission. If you, without the,
Have you ever came across a 5, 6, 7, 6 pages of cognizance order?
Lordship, you Lordship.
Have you ever gone through?
Lordship, I have gone through, Lordship. I have gone through.
6 pages.
Lordship, kindly see. Lordship, rightly.
Generally, cognizance order is half a page.
That is my entire submission before Lordship.
Since he has applied
So,
mind and
yes,
written everything.
that if I can convince your Lordship that application of mind is contrary to the records, he has not applied his mind, then definitely Lordship will interfere in the matter. Your Lordship, kindly yesterday, you Lordship rightly point out the page 4, Lordship, kindly see. Page internal page 45, internal page 4 of the, and here Lordship is spelled out. Lordship, he is justified to prove offense 294. Lordship, kindly see this language they used yesterday. Your Lordship insisting me to read upon the languages. That is there. Lordship, kindly come to. I will show only one document. Because Lordship, kindly see, Lordship gone through that he is relying upon 2 statements of husband and wife. He has taken care of all the offences, Lordship. Lordship, kindly come to page 23. Page 22, 3 and 24. The 2 statements, all the statements I have annexed, and the very much statements available test 22, 23, 24.
23,
page 23, Lordship, of my brief.
Yes.
This is statement of the informant, Lordship.
Yes.
Lordship, kindly peruse the statement, what he has written in his statement. That is recorded.
Read it.
Lordship. ମୋ ନାମ ଧରଣୀଧର ସେଠୀ 53 years ପିତା ମୃତ ମଞ୍ଚଦିନ ସେଠୀ ଗଦାସାହି ଆଠଗଡ଼ ଥାନା ଆଠଗଡ଼ ଜିଲ୍ଲା କଟକ ଆଜି ଆପଣଙ୍କ ନିକଟରେ ମୋର ବୟାନ ଦେବାର ଏହିକି ଯେ ଆମେ ମୋର ସ୍ତ୍ରୀ ଗୌରୀ ମଲ୍ଲିକ ବ୍ଲକ କଲୋନୀ ଆଠଗଡ଼ରେ ଏକ ଘରେ ଭଡ଼ା ନେଇ ନାନୋ କମ୍ପ୍ୟୁଟର ନାମରେ ଏକ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ଅନୁଷ୍ଠାନ ଖୋଲିଅଛୁ ଯେଉଁଥିରେ ସ୍ଥାନୀୟ ଅଞ୍ଚଳର ପିଲାମାନଙ୍କ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ଲାଭ କରନ୍ତି ଗତ 15/12/2017 ତାରିଖରେ ଆଠଗଡ଼ର ସତ୍ୟପ୍ରକାଶ ରଥ ହିଜ୍ ନେମ୍ ଲର୍ଡସିପ୍ up to Lordship the third line ଆସି ଅନୁଷ୍ଠାନକୁ ଆସି ଅନୁରୋଧ କରି କହିଲେ ଯେ ଆପଣ ଡିଜିଟାଲ ଇଣ୍ଡିଆ ମାଧ୍ୟମରେ ମୋ ପିଲାମାନଙ୍କୁ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ଦିଅନ୍ତୁ ପ୍ରତି ପିଲାଙ୍କ ବାବଦ ଆପଣ 300 ଟଙ୍କା ଲେଖା କମିଶନ ପାଇବେ ଆମ୍ଭେ ସେମାନଙ୍କୁ ଉକ୍ତ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ବାବଦ ଚୁକ୍ତିନାମା କରିବା ପାଇଁ କହିବାରେ ସେମାନେ ମନା କଲେ 2018 ମସିହାରେ ସତ୍ୟପ୍ରକାଶ ରଥ ଆଉ ଏକ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ଅନୁଷ୍ଠାନ ଢେଙ୍କାନାଳରେ ଖୋଲିବା ପାଇଁ କହିଲେ ତାଙ୍କ କଥା ରକ୍ଷା କରି ଆମେ କିଛି କମ୍ପ୍ୟୁଟର ଟେବୁଲ ଚୌକି ଅନ୍ୟାନ୍ୟ ସରଞ୍ଜାମ ତାକୁ କିଣି ଦେଇଥିଲୁ ଓ ଢେଙ୍କାନାଳରେ ଏକ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ଅନୁଷ୍ଠାନ ଆରମ୍ଭ କରାଯାଇଥିଲା ଇତିମଧ୍ୟରେ 2500ରୁ 3000 ପିଲା ଉକ୍ତ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ସମସ୍ତେ କରିଛନ୍ତି ଆମ୍ଭେ ଯେତେବେଳେ ସତ୍ୟପ୍ରକାଶ ରଥ ଓ ତାଙ୍କର ସହଯୋଗୀ ମାନଙ୍କୁ ଆମ୍ଭର କମିଶନ ବାବଦରେ କହିଲୁ ସେ ଆମ୍ଭକୁ ଆମର ଜାତିର ନାମ ଗାଳିମନ୍ଦ କରିବା ସହିତ ଜୀବନ ମାରିଦେବା ପାଇଁ ଧମକ ଦେଲେ ତ ଲର୍ଡସିପ କାଇଣ୍ଡଲି see the very much language the learned court will have used and reflected in the order sheet and relying upon the 160 statement lordship kindly this 160 statement I have done the certified copy and annexed to it application
Right.
so prima facie lordship it appears without going to other facts I have other arguments lordship if lordship see the offense is not
No, again come to the impugn order now.
lordship
Page
lordship 45 lordship
it is attributed to whom?
attributed not in lordship kind he is given he is in general manner and he is saying relying supported by their 161 statements it is appearing a prima facie case so language is used lordship is quoted Hon'Ble has quoted supporting the 161 statements lordship kindly see that is never available.
Okay, please take your seat.
Lordship,
Mr. Maharaj,
Yes.
come to page 45.
Yes.
See where from this fascinating words he borrowed the trial court.
Page 45.
45. Just
Where it ends. From that I am starting.
no, yes.
Yes, madam.
No,
From
he
yesterday.
abused him in obscene words.
Exactly.
So and so.
Say kotha
And so.
appears.
You show me these words
Yes,
in
I show.
161 of somebody.
No. 161 is recorded only to corroborated or contradiction so far the FR is concerned.
No, he is reproducing. He says in 161 statement, this has been said.
Say
You show me 161.
ମୁଁ 161 ଦେଖେଇବିନି ମୁଁ ଅଲଗା ଷ୍ଟେଟମେଣ୍ଟ ରେ ଦେଖେଇଦେବି ମୁଁ ଦେଖଉଛି ସେଟା
Yes.
ମୁଁ ଆଜ୍ଞା ଟ୍ରାଏଲ କୋର୍ଟ and your lordship had pointed out very good question that whether have you ever been had this 6 pages of cognizance but in my practice my lord last 22 years
Generally one word.
only
it files
four
cognizance.
lines only 4 lines cognizance prima facie
Yes.
case made out cognizance taken.
You show me this.
So now my
part.
page 45 the learned trial court has observed that aspired in his cast in saying ଜାତିରେ ଧୋବା ଚିହ୍ନିଲୁ ଛୁଇଁଲେ ଛୁଆନ୍ତି ହେବ ବ୍ରାହ୍ମଣ ମହାନ୍ତିଙ୍କ ଆଗରେ କଥା କହୁଛୁ supported by this statement your lordship may
Supported by their 161 statement.
Yes.
Is also.
This is my lord.
Where who has said this?
Yes, sir. Now I am right.
So tell me the informant's statement. Show me.
Yes, sir. Now my lord, your lordship may kindly turn to page 16. Page 16.
16.
Then I will go to
16.
16. Then I will go to 161. Page 16 look at lordship got.
Yes. I'm
Nine.
there. I'm there again.
After my lord, just middle of the statement, middle of the. ଏବଂ ବାବୁ ମହାନ୍ତି ମୋତେ ଅତି ଅଭଦ୍ର ଭାଷାରେ my lord lordship got it. In the middle, after 22,500.
Yes.
Just below the line.
Yes.
ବାବୁ ମହାନ୍ତି ମୋତେ ଅତି ଅଭଦ୍ର ଭାଷାରେ ଡ୍ୟାସ୍ ଛୁଇଁଲେ ଛୁଆନ୍ତି ହେବ ଜାତିରେ ଧୋବା ଛୁଇଁଲେ ଛୁଆନ୍ତି ହେବ ଲର୍ଡସିପ୍ got it? ବ୍ରାହ୍ମଣ ମହାନ୍ତିଙ୍କ ଆଗରେ କଥା କହୁଛୁ which has been reflected in the impugned order passed by the London SDL.
Okay.
And then, so far the 161 statement is concerned.
And
Ambe
this
jetteବେଳେ
words are also there.
exactly the same word has not been explained by the
ଅତି ଅଭଦ୍ର ଭାଷାରେ bracket ରେ
yes, so it's pura details lekha hada. FIR is very clear. Now in 161 minor, in 161 ये जो आरंभ होइछि सेटा एक्सप्लेन करिनी कि व्हाट आर दी स्लैंग लैंग्वेज से कहिला आम्बे जेतेबेले सत्य प्रकाश रथ ओ तांकर सहयोगी मानको आंबर कमिशन बाबद रे कहलु
जाति नारे नहीं
से हमकु हमर जाति नाम नेई गाली मंद करबा सो दिस जाति नाम नेई गाली मंद करबा लॉर्डशिप गॉट इट नाउ माय लॉर्ड आई एम टेकिंग टू योर लॉर्डशिप्स कंसीडरेशन टुवर्ड्स माय लॉर्ड द लास्ट व्हाई दिस इन्वेस्टिगेशन हैज बीन my lord, intentionally I am from the prosecution, I am also saying this investigation is not at all carried out in pursuant to the law. This is absolutely vast. My lord, this you also may kindly see the order why the learned court bill has observed what happened to this the accused person namely.
Yes, I am.
But that has been taken note of why the investigative officer are not complying the order.
There are prima facie.
Lordship, again, perhaps I'm not able to convince a lordship.
No, I am convinced.
No, Lordship, perhaps I am not able to. Lordship, kindly, my learned friend is relying page 15. What is that page 15, Lordship? Lordship, kindly come to page 15. That is, yes, Lordship. That is FIR, that is, Lordship, kindly come to the page 15 for a moment, Lordship.
Yes, I am.
Yes, Lordship.
Right there. I'm right there.
Page 15, Lordship, kindly come to it. It is also.
It is a very detailed FIR.
Yes, Lordship.
Statement is there.
At page 15, Lordship, can you see page 15, Lordship, kindly come to subject. Subject here, Lordship, it is an incident from 1/3/2018 to 30/3/2019. And Lordship, kindly say this FIR has been lodged on 15/10/2019 before the police station. Then Lordship, kindly come to 161 statement. This is also recorded on 15/10/2019 by the same investigating authority. Lordship, this is the statement of the informant before the investigating agency. Lordship, had it been the facts, Lordship, it could have been reflected in the 161 statement. Lordship, see the peculiar the case.
No, the 161 statement which you have read,
Lordship,
the last two lines is enough for the purpose of taking cognizance. Forget about the
Lordship.
Last two lines in 161 statement.
Yes, then Lordship, then my case begins from there, Lordship. Perhaps I have not concluded my argument. Then my argument starts there. Lordship, kindly see what is written. He has written, Lordship, it is supported by the many documents, Lordship. And for the reasons because I have abused to his caste, then 3 of the SC star comes to play. Lordship, kindly come to the provision of law. Lordship, kindly come to section 3.
See, this is there the cognizance phase. Why should I go in prima facie case?
No,
and all these things.
Lordship, prima facie.
You can argue all these things at the right stage.
No, Lordship, in the charge, Lordship is rightly saying that I may approach the charge. So far charge is concerned, I may discharge for the accused person is concerned. Now I am on the offence. My humble submission before Lordship, the court has taken judicial notice on the offence itself. When my humble submission, when the ingredients are not available with the Lordship. So,
only prima facie case.
No prima facie case, Lordship. Prima facie case, had it been a prima facie case, Lordship, kindly come to see 3 of the Act, Lordship, for a moment. Lordship, kindly come to section 3.
Yes, ready.
Lordship. Is it, Lordship, perhaps it is section 3.
Yes.
Lordship, 3, perhaps Lordship, 3, R and S, Lordship, kindly come to R and S.
Yes, read.
Lordship. Intentionally insults or intimidates with intent to humiliate a member of scheduled caste or scheduled tribe in any place within public view. This is, Lordship, the most Lordship, essential requirement of the law. It must be happened in a public view. If I will scold a person in his house, in a compact room, this offense will not mark out. If I have scolded him in a public place by abusing his caste and trying to, Lordship, lower down his image, then this offense will come out, Lordship. Then, Lordship, I will come to section, Lordship, also S. Abuses any member of a scheduled caste or a scheduled tribe by caste name in any place within public view. So that's why, Lordship, this investigating authority has not recorded the statement of this husband and wife. He has recorded many witnesses, and none of the witnesses either has supported to his allegations or has just spelled out a single word to make out this case. So that's why my humble submission, and Lordship, another offense, Lordship, he has taken cognizance of 294. Lordship, kindly come to offense 294 also. 294 also comes with, Lordship, 294. It is also the ingredients, it must be in a public place. So, Lordship, kind of the entire sequence of events and the entire the projection of the investigating authority. He has recorded statement of many accused, many witnesses. None of the witnesses have supported that the incident has happened in a public view. That's why he has requested to run a court below to the judicial magistrate, Lordship, because there is insufficient evidence. If at all, Lordship, in this case, will be Lordship, Lordship will allow Lordship himself has not come up with a case, and Lordship kindly see the very day the statement is given. Lordship, absolutely on the face of the Lordship, it appears to be offense is made out. But if Lordship look in the ingredients of the case, none of the ingredients are made out. And Lordship kindly see another finding I'm giving another law. Lordship kindly come to Lordship page 46 for a moment. How the learned court bill has not applied in judicial mind. Lordship kindly come to page 46. Only one sentence, Lordship, page 5. Many of the accused persons are prima facie appearing to public servant. Let's look at the basic requirements of law. Then 197 comes to my protection. If once, Lordship, the court below himself admits, Lordship, had it been investigated, we don't have any case, Lordship, because then they might have been ignorance of law. But here is judicial officer, while observing himself in the order of cognizance.
Are you a public servant?
Yes, Lordship. So, Lordship, then, Lordship, this, he is admitted in the cognizance order. Lordship, and Lordship, it is a case, Lordship, if a Lordship issue notice the informant, they don't remember the case also, Lordship. I have examined because Lordship can see the what sort of FIR is this. He is narrating a story from 2017 to 19, and Lordship, it is hopelessly barred by law of limitation. And Lordship, so 197 comes to rescue me, Lordship, and 3FS and other offenses not applicable to me because none of the ingredients on the prima facie on the face of the records is not available. While first, Lordship, go to trial and go appear before the learned court below and file a discharge petition. Please discharge me.
Yes.
So, Lordship, the investigating authority had a case in the Lordship, usually is support learned court below is supporting the order of the investigating authority. Then, Lordship, usually the very cryptic order is required.
Okay.
But here,
I'll pass.
Lordship, grateful.
Yes. Thank you.
Lordship, grateful. Lordship, I have produced any judgments, Lordship? I have bring the genesis of the Cognizance, and Lordship, I
don't think judgments are required.
Lordship, grateful, Lordship.
Sufficiently argued.
Grateful, Lordship.
Yes.
Grateful.
Thank you very much. Yes. No, I did the order.
Yes.
42. Yes. Yes, sir. 42. Non-APS. 42, sir.
The short point is involved, but that ground has not been taken, I think. And that a complaint petition was filed, a trivial incident with regards to selling of car. But
when vacations are approaching, why heavy matters are coming to the court?
It's not a heavy matter. It's a case, annexure 1, I have challenged, which arises out of a complaint petition. The complaint petition, may kindly see paragraph page 17. That is not supported by any affidavit as required in 2015 Supreme Court.
Priyanka. Where is the complaint?
Complaint is last page, we see page 17.
See, last line, page 17, affidavit is not written, but that is in the form of affidavit only.
No, it cannot be.
Anil Mahapatra,
complainant hereby
declare that the contents of the complaint
but it's
are true to the best of
the if paragraph 19.
Only thing is one word is missing, affidavit.
So that is sufficient one. Because they have to ascertain, because the law
in my personal view is these are not actually. Even if it is affidavit written at the top of it, this is not affidavit. Full affidavit, supporting affidavit has to be there. But this is
I raised this ballot for immediately after 2015 Supreme Court was pronounced. In 2016 or 17, my lord, I raised this point and it has been quashed. It was an invocation code.
But it is not the part of affidavit.
It cannot be. Because the guidelines the apex court has fixed therein, it cannot come on that category.
Madam, issue notice to opposite party number 2, written rules also. Mr. D.P. Dhar, senior counsel, appearing for the petitioner, submits that the present case is arising out of a complaint petition under section 156(3) CRPC, pursuant to which the FIR was registered. The complaint he has taken me to relying upon the copy of the complaint which is placed on record. He submits that as per the judgment of the Honorable Supreme Court in Priyanka Trivato versus so and so, reported in so and so, there is no supporting affidavit filed by the complainant with the 1cc case. Therefore, the complaint case was not maintainable. Issue notice so and so. Written. Okay. In the meantime, I have to stay the proceeding. In the meantime, proceeding in 1cc case number 52 of 2022. State 52 of 2022.
That has been converted to PS now. Bargot PS case number
corresponding to Bargot PS case number
699 of 2022.
699 of 2022. Investigation is on, na?
Valid.
Yes, yes. Then how I can't stop investigation?
No coercive action can be taken, madam. We say. I have not gone for any anticipatory bail.
Because persons to next paragraph, persons to the FIR being registered, investigation is going on. Therefore, proceeding cannot be. Therefore, no proceeding is pending, except the investigation. In that view of the matter, there shall be no coercive action. No coercive action shall be taken against the petitioner until next date appeal.
Subject to condition,
subject to condition that the petitioner. The moment I have to subject to condition that it looks like a 438.
No
coercive. So therefore, I don't write that. No coercive action. Simple.
No coercive.
The moment.
The
moment I say that, then it is kind of anticipatory bail.
I'll fix up a date.
I'll fix it till next date appeal. Immediately after vacation.
Yes.
Till next date.
Before Lordship takes up 121, there are 3 matters. The Lordship's already, I told her the judgment is reserved. My case is also not covered by that. I have also given the written note.
Yes. 121. Partnership form.
None.
You have partnership.
Same FIR, I have also relied upon the judgments I have sent.
Yes. Please give that. Huh?
Yes, it is in the written note.
Thank you. Thank you very much. Yes.
44.
44.
Item 51.
51, they come?
Yes, ma'am.
Are they appearing?
And they have joined in my video call, my lord. They are unable to join in the BC, my lord. They are unable to join in the BC, my lord.
So why are you mentioning them? Only to say that they are not.
They are joining in the video call.
Some small child is appearing.
Yes, no problem.
Very nice. This is the best way of conducting cases in High Court.
They are not able to join in DC. I have approached.
Don't reduce the proceeding to this level.
Sorry, man.
Because facility is given doesn't mean that you will reduce the proceeding to this level.
Yes, sorry.
Call them. It's better that for you also it is better. What,
yes.
Tomorrow I can accommodate you.
Yes,
tomorrow.
Yes,
it will be tomorrow.
51 tomorrow. Yes.
Because tomorrow something happen, they will ask you to move application, or some application is moved against you also.
Yes, ma'am.
You may be doing bona fidely believing whatever they are correct.
51.
It's not same.
Yes, ma'am.
Yes. Tomorrow. Yes.
44, my lord. I have my prayer is for quashing of criminal trial on the ground that the other co-accused persons have already been acquitted.
Obviously, they'll face the trial, they will be acquitted.
It's a case of
If you are absconding, then you will be like that only. What to do?
Yes, because my lord,
It's a
Lordship
case
may
of 302.
302, my lord. Lordship may see the
When will you appear?
will take instruction, my lord.
You appear 302, no question, please.
Because my brother have already been acquitted.
That's right, because they appeared and they faced the trial.
Lordship judgment is also within that figure which has been reported. If
In 302.
no, my lord, it is with regard to NDPS.
That is in the NDPS case where chemical examination report was not there.
Yes.
My lord.
So therefore, there is no point subjecting the petitioner to trial. That is why
On that ground, trial court acquitted all the accused
all,
persons.
therefore I acquitted all.
That is why your lordship interfered.
My lord. Rakesh
It
sir.
is 302.
Yes,
Because my lord, here in last observation, the trial court has opined that enter this case as a mistake of facts.
Maybe, but
He has been granted first or second order, but he has not complied that.
you appear, I'll expedite the trial. You will be acquitted.
Lordship may take up this matter day after tomorrow. I will take it.
Why I'm not on the mercy of your instruction of your client. I will dismiss it.
My lord,
I'm giving you relief.
my lord.
I'll expedite the trial in view of the fact that the other accused persons are acquitted. You have already armed with an order of anticipatory.
Yes.
You go and surrender,
My lord.
and you will be acquitted within a month.
My lord.
Any judge will be happy to do it because a disposal will go to his credit. Okay. When will you appear? 30th March, June, on or before. Okay. Petitioner has challenged, petitioner has filed the present petition seeking quashing of the entire criminal prosecution initiated against him. In connection with Tomodra PS case number 75 of 2020 and the petitioner, the investigation was completed, charge sheet was filed, however, the petitioner has been absconded. The two co-accused persons were apprehended and subjected to trial. The additional sessions judge Baleshwar by order dated judgment dated 1/3/2024 in ST case number 361 of 2022 as recorded a acquittal in favor of the co-accused persons. Co-accused persons. Which paragraph you are saying?
Acquittal, my lord. The page 9 is annexed to
It will help you. Where it says that it is defective.
okay.
3-page judgment you have not ready.
Well, para 7 of the
Yes.
judgment. Para 7 and 8. Page 13.
Which part?
Last 5 lines.
Para 7, my lord, para 7, last
It
follow.
only says that the prosecution could not prove the case.
Prosecution has already declared upon extrajudicial completion.
Where does it say that it is a fake case or what?
My lord, para 8. Enter this case as a mistake of facts. Page 14.
No, para 8 doesn't say.
Mistake of fact.
Where is that?
Yes, my lord, page 14.
Para?
Page 14, para 8, sub para, just 437A of CRPC, just below. Enter this case. Enter this case as mistake of facts.
Right on. Inter alia stating in that para inter pura tolo jane likh do page 14. Relying upon the aforementioned judgment, the petitioner seeks quashing of the criminal case against him. I'm not the petitioner has been since the petitioner has been absconding and has not cooperated with the investigation. I'm not inclined to instigate this petition. However, the petitioner is directed to appear before the court on or before 30th of June 2024 and away all remedy under law. In view of the fact that FIR is registered on when? Which year? FIR is
2020, my lord.
Yeah?
2020.
20.
My lord.
FIR was registered on 17/7/2020 and before it is the case, we should be experienced in the trial court prove the trial as expeditiously as possible. Which is this observation. Next.
46. 45.
Right. Your Lordship.
Yes.
My lord, petitioner filed this application with prayer for a modification of some parts of the order of the revisional court, my lord. Matter relating to release of vehicle, my lord.
What are the conditions?
Condition 5 lakhs of a bank guarantee, my lord. Petitioner is the owner of the Tata Magic, very small vehicle. Your Lordship, kindly see that is the page 21.
I could see that. Where is the valuation report?
My lord.
Where is the valuation report?
Verification I have not annexed. Valuation report also I have not annexed, my lord. Your Lordship, very small.
And how the court has arrived at this value?
Court has not arrived on the point of the value. Nowhere, my lord. Nowhere court has not come to the regarding evaluation of the vehicle, my lord. Only may I permit page 21, para 10. Ergo the revision petition filed
What
by
is this vehicle?
Tata Magic, my lord. That is Tata Magic Express 9+D.
You tell me the value of the vehicle so that I can review it.
Perhaps now since 2000, perhaps maximum to maximum.
Can I pass an order on the basis of perhaps? Perhaps if, but can I pass the order? But you have to see, you are agreed by the fact that the court says that bank guarantee of 5 lakhs. The value of the car is this much.
Nowadays, Tata Magic Express value is the maximum to maximum 5. New vehicles cost is more than maximum to maximum 5 lakhs.
It's a case of accident. It's a case of accident. Your Lordship, may just drawing your Lordship kind attention to impugned order page 4.
What is the offense?
Offense 304A.
Yes, it's a accident.
304A 279.
Insurance, my lord. That is why the condition has been imposed. I am reading, my lord, only 4-5 lines. Where there is no insurance cover of a vehicle in owner should be directed to offer security or deposit an amount adequate to satisfy the award that may be ultimately passed as a condition precedent for release of the seized vehicle involved in the accident. If such security or cash deposit is not made within a period of 3 months, appropriate steps may be taken for disposal of the vehicle and hold the sale proceeding in deposit until the claim case is disposed of. The appropriate government may consider
that is the reason valuation of report is must.
Yes.
Get a valuation report. Learned counsel for the petitioner seeks an adjournment to place on record the valuation report of the vehicle. Vehicle on the basis of which the condition imposed by the court below while releasing the vehicle could be altered. Could be altered. the land court below, while allowing the application under 457 CRPC, has imposed a condition for furnishing of bank guarantee of rupees 5 lakh.
Yes.
5 lakh. This is the matter on, sir. You get a report. Privately, you will get a report. So that I can alter it.
After vacation, my lord.
Yes, after vacation. Yeah.
46.
Wait, please, Your Lordship. Item number 46, my lord. It is a case of 395. I want to add the complainant as the opposite party to this proceeding. Your Lordship.
Okay.
Because, my lord, the complainant, they have never stated anything in the trial court, my lord. 5 number of co-accused are apprehended. Sorry, 5 number co-accused are in this case, and the police submitted charge sheet. 3 of the accused faced the trial and they acquitted, Your Lordship.
TI period? No.
No TI period conducted, my lord.
Learned counsel for the Mr. Sahu, learned counsel for the petitioner seeks leave of this court to implead the informant.
Informant and her friend.
Huh?
Her friend. 2 victims are there in this case.
Informant and the victim. As opposite party number 2 and 3.
Well.
The same is permitted. Let him implead both the informant and injured. Informant and victim. Victim as opposite party number 2 and 3. Upon impleadment of those respondent, issue notice. Yes.
Grateful.
Yes.
47.
May I please, Your Lordship? Your Lord, 311 petition has been rejected by the learned court below, my lord. As because, my lord, some
What is
relevant
the offense?
offense, my lord, 376.
376.
My lord. Filed petition before the learned court below.
Which witness?
My lord, PW1 and PW12. One is the informant and 12 is the victim.
PW1 and
PW12, my lord.
12. Show me their depositions.
The my lord, Annexer 1, deposition copy of page 8 to page 14. And my petition, my lord, that
Foxo is not there.
No, Foxo is not.
Foxo is not there. And my petition on the
No cross-examination.
I have given the question in my petition.
Yes, sir. Yes. Yes, Mr.
But you also may kindly turn to page 20.
20. Yes.
That is the finding, my lord. The peer the case record, my lord. This is all these questions have been confronted and the question has been corroborated. You also may kindly see I am reading peer the case record of 164 statement of the victim, and the victim has stated that while taking to accused over phone, talking to the accused over phone, the letter has stated in his name as Prakash. She has also stated therein the accused had given her money to sell her. It is also stated by her in her 164 statement that she came to Sayedpur on 10/6.
Why the trial court is going into all these things? What he has said, what?
Because the question has been put, the questionnaire has been discussed. The questionnaire which has been put forth before the trial court.
Relevancy of
yes. That is why that has been.
No, but come to the deposition. Nothing is no cross examination. Yes, cross examination. Is there?
Yes, cross examination. Page 12.
Page 9. It is cross examination.
And some important question has been left out. That is why.
And yes, page 12 and page 9, and you have cross examined.
Cross examined.
Yes. Then
relevant question.
Relevant question has been left out. That is why 311
in that context, then the trial court is correct. Then.
That is why this has been.
PW1 may not be, my lord. PW12 as she is the victim, my lord. So some relevant question may be put to her.
What are the relevant questions? The relevant question is examined with the trial court saying that it is not relevant.
No, my lord. I have given the questions, my lord, in my petition on
that those questions are evaluated by the trial court.
No,
if in order.
I am placing the questions,
yes.
My lord, that questions, my lord. PW victim has stated in her 164 statement that she was talking over phone with the accused person and he told his name as Prakash, whether it is correct or not. This is one question.
This is one question. And the answer is page 20.
No.
The trial court has dealt with this question.
And my lord, the next question is, the victim has stated in her 161 statement that she came from her house to Saidpur on Wednesday on dated,
10/6/2018.
Yes.
but Saidpur on Wednesday dated 9/6/2018.
I mean, that is also dealt just
But in
whether
a,
it is 9/6 or 10/6,
that
is also dealt with by the trial court.
say question ta taku the next question was the victim has stated in her 164 statement that Manu Sethi had taken money from accused Goppa for selling her. Whether it is correct or not, this is one question, my lord. And
So you don't have a case. And in January 21st January 2020,
no, 24.
2020, this examination has taken place and deposition has taken place. Now, you are moving application after 4 years. Right now, the petitioner is agreed by the order dated. What is that order dated? Order dated 18/6/2019, whereby his application under section 311 CRPC for recalling.
Order dated 2/4/2024.
2024.
2/4/2024, whereby his application under section 311 CRPC for recalling imbue 1 and 12 has been rejected. The trial court, by evaluating the relevancy of the proposed question to be put to the said witness, have arrived at the following conclusion. Page 20, peruse the case record. Very good. Peruse the case record to the paragraph. 20. I'm not inclined to entertain this petition.
The capital punishment.
Dismiss it, hence it dismissed. However, dismissal of this petition shall not preclude the petitioner to lead his defense in this regard. You can lead your. Yes.
48.
May I please, Your Lordship?
Yes.
My Lord, this is for questioning of the criminal proceeding.
Yes.
Allegation is against Diyara, Sasu and Sasur. The informant is the Bhauja or Bohu. The offences are under section 376, 294 and 34 of IPC. On the face of the affair.
The petition is filed by the
Bhauja.
husband.
No, my lord, Bhauja.
Vikas Vishwal.
Top we were. Oh, my lord, sorry, my lord. This is Diyara.
What are the allegations against you?
Allegation is commission of rape.
Then?
My lord. No, my lord, this is a family dispute matter. If the notice can be issued to the informant.
What? Rape is a family dispute.
No, my lord, there is family dispute. That
appear or surrender before the trial court on or before 30th of June 2024 and move appropriate application
and comply the order passed in
for release on bail as per the direction of the coordinate bench. At least 31st June, till then you are safe. Yes.
49.
Yes.
This is challenging the order of provisions. Actually, this provisions order is passed 49. Against the complaint case. This is a complaint case and counter complaint case. First complaint is filed by the daughter-in-law of this petitioner, and second complaint is filed by the Samudani of the younger brother. Again, देखो सेट अच्छी.
In the petition, you neither that Samudani nor the wife.
Samudani के अस्कला Samudani.
Where are they? That you should have made them party.
Sir,
it's a complaint case.
I will permit to permit here.
And you are challenging an order in a complaint case. You are not making them party. Right now, for the petitioner seeks to implead the complainant. In the present case is arising out of 1cc case number.
1cc 34
by 2023.
NVW has been issued. I will pass it and go and appear. That's better. Right. The present case is arising out of 1cc case number. Which one? First one, second one?
Second one.
Huh?
34 of 2023.
34 of 2023. By the order dated 17 to 2024, NBW has been issued by the
Learned
JMFC first class,
Yes.
Basta.
Yes.
Basta. So on instruction, then submits that his client would appear before the court on or before 30th of June, so and so, and seek appropriate remedy under law. Subject to petitioner appearing before the court on or before 7th day, the NBW issued against the petitioners on
Date 9.
17 to 24 is satisfied. Yes. Yes. 50.
Bail jump case my lordship. NBW order 18/8 earlier bail order date 4/2/19.
NBW 18/8
Yes, ma'am.
bail है 4/2/19.
Yes, ma'am.
5-1.
Okay.
54. our pen तो इधर क्या है नहीं अभी चल नहीं पेन चालू नहीं yes 50 54 what happened 51 52
52 टा से विजिलेंस रे जो किया है कोई नहीं बोले अन्य एक ही बेल हो गया
सब्जेक्ट कौन था 51
Please, your lordship. 54, my lords, there are 4 items of that, 4 revisions.
My lords, again the same thing.
No, I have a right to address your lordship.
No, no right to pre-audience.
You have taken
You
up
have
my
actually
rights.
right to argue. Again, my lords, that is the reason the other day I am saying
My lord,
let the time be
one
fixed.
is-
Now 10 minutes are left. That is his purpose is served. That day, urgent again to
What
today.
benefits I
again-
derived? No, what benefits I derived at the end of the day? Only thing is, my lord, this is a 4 revision applications there. If I take 10 minutes for each case, means 40 minutes is required to mine. 3 other lawyers are there in other cases, my lords. How much time?
what is this matter
This
My lords,
matters, my lord,
my lords,
rejection
let me
of
argue.
this is
No.
application.
This is the- Again, even if I had to.
No, we have a right to
No,
address.
you don't have a right of
Yeah, you
pre-audience.
have a right.
No, you are not a
You cannot
designated
take
senior
somebody's
counsel,
rights.
nor you are an advocate general.
You can't shout and
No.
shout and
That is basic fundamental. You cannot.
We have
Opposite parties don't have a right of
I
pre-audience.
think you are closing the day. Why should you?
That's what, my lords, let me submit. Here, my lords, it's a vigilance case. Allegation is it's a road constructed under the Pradhan Mantri Sadak Yojana. So, your lordship knows, it's a central government project governed by the central government notifications. While this was going on, my lords, on the halfway stage, suddenly before completion or before this vigilance case crops up, I was working as an executioner for a certain period. My predecessor, he was also an accused. Unfortunately, he's no more. The power of attorney holder, the contractor, is no more. Only 3-4 of us are left. Now I am the executioner, assistant engineer, and other staffs. Here the allegation is there is some mismeasurement, and without authority, some changes have been made. And for personal benefit.
Sir, you are also appearing in.
Yes, my learned senior is there. My lords, I have given the other day a list of documents.
Yes. You are challenging the entire prosecution.
Proceeding. No, the charge. Yes, my lord. Before that, I am clarifying. They did not supply the full papers. Charge was framed. We objected to that. Court refused. We came up before this honorable court. Then they supplied the papers. So this court said, now you go back because the papers you have received. We went back. This is the second round. So
Charge is in frame.
against the
charge you have come.
Yes. So far as the delay and other aspect, my learned senior will argue. I just want to brief the overall thing. Lords, what is the case about? My learned may kindly have a look. Scan it. My lord, I filed it on 8/5.
How much time will you take, by the way?
10-15 minutes at least. Yes.
About roughly half an hour. Because
That day, that is what I prayed.
certain interpretation of all the clauses. Our basic case is, my lords, subject to what my friend says. My lords, the agreement itself stipulates that payments are not made for the works actually executed. payments are by way of an interim advance. And ultimately, at the time of settlement of final bill, everything will be regularized. So, my lords, this is the clause in the agreement itself. It's not that I'm saying it as a matter of course. The agreement itself stipulates. I don't think I need this while submitting. Okay. My lords, a bill shall be submitted by the contract each month on or before the date fixed by the engineer in charge for all works executed in the previous month, and the engineer in charge or his subordinate shall take the requisite measurement for the purpose of having the same verified and the claim as far as admissible adjusted if possible before the expiry of 10 days from the presentation of the bill. If the contractor does not submit the bill thereafter, provided that if any balance of the 7% securities are outstanding, then it will be to make up the balance of the all such payments are intermediary and shall be regarded as payments by way of advance against the final payment only and not as payments for work actually done. So their allegation, they taken
not against the running bills
running
in advance.
It is not actually against the works done, and their cases also, my lords, they have taken measurement after 3 years of the work executed, which this honorable court in 2 cases have already held, and in a recent judgment have already held, that you take a measurement after 3 years, you cannot arrive at the right conclusion, and accordingly quash the entire proceeding. And on the basis of those measurements, they have said that you are misappropriate. There is a mismatch of 21 lakhs. 25 lakhs are not valid.
Which you have taken as an advance.
Which the contractor, I'm not the contractor, which the contractor had taken as an advance. Now, it is an admitted position that 61 lakhs still remains withheld from the contractor's bills. So, if 61 lakhs, if it is taken as an advance, then, my lords, ultimately, at the time of
question of misappropriation
by us, and further this is the crux, and the further cases, my lords, that we have not done the actual measurements. It has been done by the junior engineer. We are only supervising authority.
Then can I fix it exact timing tomorrow or Monday?
Yes,
Monday, my lords, your
or
lordship.
Friday?
Any day, your lordship, please.
3 o'clock. Let us fix it at 3 o'clock.
That day I prayed that.
Monday.
You know the see we
No, no.
today, somehow today we derailed.
What is overburdened, there is no dispute. But unfortunately, this is 2007 and on the conduct, your lordship.
FIR was
2007.
Very old.
We are all retired, my lords.
Yes, yes, Mr. Shall I fix it at 3 o'clock and finish it up? There are 4 matters at least. You can finish up.
For Monday?
No, I mean, admit it.
What is it?
Lord, I don't stand on the way because I'm not benefited, my lord. I am interested for disposal, but this is a case, my lords. At least 4 counsels are there. At least 2 persons will argue in all this, a factual aspect in all this thing. And I have to address it or to satisfying the all grounds. They want to take me as granted, my lords. They will say something. I'm not the person, my lord. I will place all the matters. But that time, at least a breathing gap is required at least for half an hour or 20 minutes or 20 minutes. But that's
You take it. That's why. That's what I'm saying.
What I suggest, my lord.
I'll fix it at 3:30.
No,
and we'll proceed.
Yes, no problem. No problem. I am ready, my lord.
Let it go on.
More than obliged.
I am ready, but what I suggest, my lords, when the case was last listed, my lords, I suggested that another 2 cases are left out, Mr. Kanungos. I suggest, at the outset, I was suggesting, my lord, your lordship add another 2 accused, the same cases, my lord, of Mr. Kanungo. When I was trying to give another 2 cases, my lords, 172 ta notila. Last time I was trying.
Now it has come.
It has come out. Now, today I was trying to impress your lordship, lord. This is a case at least 40 minutes, minimum 45 minutes required.
Tell me the time. That's what I'm saying.
I am ready, my lord, now also. But this is not a time to take off hearing matters, my lord. That is, my lord, your lordship fixed tomorrow, day after tomorrow.
Again, your lordship
See,
not
the hearing
got
matter,
the trust of
any
the
time is a good time. What to do?
No.
Because see the pressure in from morning, evening, the situation will remain always.
Yes, my lord.
So from that only you have to take out time.
Tomorrow, day after tomorrow, any time.
Okay.
Monday. Tomorrow, day after, I'm
Monday 3:30, I will hear it. Let it go till 5 o'clock, no problem.
Obliged.
Obliged. Monday 3:30.
That was my endeavor, only to take it.
Okay, 3:30.
We are also
Time
obliged for that.
spots.
3:30 Monday, next.
Obliged.
Yes.
We are also obliged for the endeavor.
Yes, we'll jump, at least we'll jump.
57.
57. Mr. Ragda, just see. We'll jump matter. I'll tell you for bail on?
But no step taken, he was on bail.
When?
Bail देना थी NBW 26/12.
He was on bail for, he was on bail for 26/12/2023. 500. Yes.
58.
Yes.
May I please, this is a Belgium matter, वाला. NBW issued on 23/4/2014
Bail
and
12/5/21.
12/5/2021 is the bail order.
12/5/27. Okay. 500. Yes. Next.
59.
Belgium Manor, order dated 15/3/2024. NBW issued on 15/3/2024. Running case 12. He was on bail during trial. He was on bail by the Honorable Court.
Do you have the date or not?
BL date, वाला BLAPL 2326 of 2018 वाला was granted bail.
I am asking date, sir. He
Date?
was on bail. He was on bail. 15/3/2024.
Para 4 hours.
Yes. 500. Yes. Next.
60.
Bail date, my lord. 4/4/2023.
4/4/2023.
23. The date of bail, mark. Date of warrant is
22/2024. 500. Yes.
61.
61 में please. Belgian matter, Manoj. 19/9/2019, the order of the NBW was on bail on 10/9/2009.
10/9/2009 and 19/9/2019. Okay, 500. Yes.
62.
Obliged, sir. Hello.
Yes, my lord.
62.
My lord, the petition challenging the NBW order dated 4/3/2024, my lord. And the only reason that, my lord,
You tell me when you got the bail.
my lord, ମୁଁ ଏପର୍ଯ୍ୟନ୍ତ ବେଲ୍ ପାଇ ନାହିଁ, ମୋର କୋ ଏକ୍ୟୁଜ ତଳ କୋର୍ଟରେ ବେଲ୍ ହେଇଛନ୍ତି।
He was absconding. Or 24. No. 4/3/2020. ठीक है? 500. Yes.
63.
May I please, my lord, date of bail is 24/3/2023 and NBW issue on 27/2/2024.
500.
64.
Next is bail date is 23/3/2023 and NBW is 29/11/2023.
500.
Okay.
65.
Belgium Metro, my lord, order dated 15/3/2024, running page 12, my lord. The religion bail, my lord, 7/12/2016. Page 11.
500. Yes.
66.
66, my lord, crossing up NBW, that is bail was granted on 4/2/2017 and NBW issued on 7/12/2023.
500.
67.
Obliged.
May I please, your lordship? My lord, this is a Belgium matter. The petitioner was on bail on 21/5/2013 and NBW issued against the present petitioner 21/2024. Obliged, your lordship.
Your lordship, this is not a bail jump matter. We are challenging the order of District Judge Bhadrak. The vehicle of the petitioner was seized on 20th/9/2023 for illegally carrying liquor, and one Babuli Munda was using the vehicle, and excise police Dhamnagar arrested the Babuli Munda and seized the vehicle. When the vehicle was in the custody of the excise police, the petitioner filed a forfeit.
Simply say your application under 457 was rejected. Yes. Come, why are you saying so many things? Yes. At this time, you keep on telling the history. What happened to your application?
It was rejected.
Rejected.
Yes.
Have you filed revision?
Yes, your lordship.
Huh?
Yes, your
Revision also rejected.
Yes, your
What are the
lordship.
grounds?
Rejected that 72 is a bar to the proceeding.
Well,
But your lordship, we have not received any notice from the authorities. We are the owner of the vehicle, but we have not received any notice.
Have you established the ownership?
Yes, your lord. We have given it in the code below, as well as we have annexed the copies here.
Oh, show me the reasoning. Revisional court revision. Where is the revisional court order?
Your lordship, annexure 1 series.
Show me the reasoning. Come to the reasoning part. Yes or no? Just see what is the reasoning.
Your lordship, your lordship will have at page 18, under section 71 of the Odisha Excise Act, they have relied on. This court does not find any reason to interfere in the findings.
71. 71 is not a bar.
72 is the bar.
Yes.
Your lordship may only pass directions to the that the confiscation proceedings may be completed by the collector in expeditious manner.
Where the particular confiscation?
But that proceeding is mentioned in the lower court order at page 20.
But your lordship, we have not.
At page 22, confiscation case number 79 of 2324.
But we have not received any notice here.
Now he is giving notice. Except notice, you won't participate in any case. Even if this is allowed, confiscation will go on. What is the use of it? Won't participate. I'll expedite that.
Yes.
Your lordship, the vehicle, so the vehicle is in custody since 2023.
Application of the petitioner under section 457 CRPC has been rejected by the court of JMFC by the order dated. Where is that?
Order dated JMFC is 21/11/2020.
Where is that?
Page 20.
20. JMFC dated page 20. The petitioner filed a revision before the court of decision Vadrak wide criminal revision number 40 of 2023. The revisional court by order dated 3/2/2024 has rejected the application on the ground that in view of the bar under section 72 of the Excise Act, application under 457 cannot be allowed, particularly in view of the fact that the confiscation proceeding has already been initiated. Where is that confiscation?
Page 22.
PR 97 of.
Yes. PR, where is that?
The last 3 lines, confiscation case number 79 of 2324.
Confiscation proceeding has already been initiated by confiscation case number 79 of 2023, date 2024. It appears that confiscation proceeding has been initiated on 6/10/2023. The counsel for the petitioner submits that he has not received notice of confiscation proceeding as yet. In view of the fact that confiscation proceeding has already been initiated, which is the authority?
Collector Bhadrak.
The collector
Superintendent of Excise Bhadrak.
Superintendent of
Excise.
Bhadrak is directed to conclude the confiscation proceeding as expeditiously as possible, preferably within 2 months.
2 months.
2 months, and the petitioner is directed to appear before the confiscation authority, treating the present authority on or before adike tarikhala 15 is na, on or before 30th of May. 30th of May. With that direction, the petition will change. Yes.
69.
69, may I please, my lords. My lord, on behalf of Mr. Tanmay Kumar Manti, Belgium matter, 3 petitioners are there. Petitioner number 1 was released on bail on 13/3/2014. Second petitioner was released on bail on 20th February 2014. Third petitioner was released on bail on 18/1/2014. But in averment, it has been
NBW is 2/5/2023.
2/5/23.
500 is 500. Okay.
My lord, in averment, there are some typographical errors. So whatever dates I have submitted, my lord, that may be.
The dates which you have given, that is correct.
That is correct, my lord.
Yes, go by this date. What
Mr.
Yes. A minute, yes. Next.
70.
Bail jump, no?
May I please also. NBW issued on 6/3/2024 matter and granted bail on section 41A of CRPC on 20th August 2023.
20th August 23.
My lord.
Yes. 500. Yes.
71.
71.
Bail was on 11/5/2010 and the NBW has been issued on 23 August 21.
500.
72.
Order of date of bail is 20th January 2024 and the NBW date is 4/5/2024.
500.
73.
Please, Lordship. Lordship, bail granted on 16/5/2022 and NBW issue on 7/10/2023.
500.
Lordship, my appearance was noted for the Union of India.
Union of India.
Lordship.
In this matter, Union of India appearance. Okay. Yes.
G1, Senator.
Yes.
74.
My lord, NBW was 22/1/2024. Bail was granted on 11/2/2020.
500. कितने? How many matters? And remaining matter will be
That is item 81, my lord. I have mentioned
Item number 78.
So the approval, my lord,
I have already
that
filed.
the matter compromise, one of the accused not present, he is in behind the bar by the time, my lord.
He is not there now.
Lordship,
It will be taken up tomorrow.
tomorrow.
100. Item number 78, my lord.
78.
I have already filed the postal requisite and
78.
78.
Impugn order. 1 minute. When have you filed?
Today I filed. I have contacted with.
Was there an interim order? 78, na?
78. Item number 78.
Requisite you have filed today. Right. Serve opposite party report to today.
Item 108, your lordship. 108.
Yes.
Your lordship, the endorsement is that your lordship, noting is that your notice has been refused by the opposite party. So I pray your lordship can taken after vacation.
After vacation.
Interim order
after
continues.
vacation asu. 109 after vacation.
109 after vacation.
Interim order to be continued.
117 modification lordship allow. 117 modification of order.
What is that?
Modification of order से judgment टा refer होगा खाली.
Huh?
Judgment टा refer होगा. मेहदूद बाबा judgment टा that is your lordship.
Which judgment you are talking?
से माने bail.
You have read, I have not read. You have to tell me judgment टा refer हो. लेकिन judgment टा refer हो. Who judgment refer हो? कोटा.
मेहदूद बाबा versus CBI will be refer.
Where? In which order?
In 17 that your lordship was allowed. The order that will be
270.
117.
Okay. 29/4/2024 I have allowed.
My lord.
What does he want?
He wants
85 lordship.
1 minute. Let me complete.
He wants that Mehdud Baba's judgment is to be referred to. সেটা লিখে দিলে সে তার হয়
I am not inclined to interfere in the matter. However, the petitioner may appear before the learned court below and apprise the fact that he has already been given protection by this court while along with. See, why should I?
ସେ କହୁଛନ୍ତି ତା ମେହଦୁଦ ବାବା ତ ଲେଖି ଦେଇଥିଲେ ପଳେଇଥାନ୍ତା କୋ ଆକ୍ୟୁଜର ଲେଖି ଦେଇଛନ୍ତି
Then, as per the his whims, I will write the judgment.
କୋ ଆକ୍ୟୁଜର ଆପଣ ଲେଖିଛନ୍ତି ସେ କହୁଛନ୍ତି ତା ମୋଟା ବି ଲେଖି ଦେଲେ ପଳେଇ.
He can go and tell all these things. What kind of application? Dismiss application. He may want so many things.
He is not present.
According to his wish, I will keep on writing words.
My lord, item 126.
Yes.
I pray for after vacation, my lord.
Urgent.
My lord,
Urgent.
item 126 and the opposite party.
He is the opposite.
And the opposite party. Date may be fixed.
Date fixed.
My lord, item
126. Let us go one by one. I will take up any matter you want. But please, 118. You want an adjournment?
No.
Then Tomorrow it will be taken up. Any urgent matter, it will be taken up tomorrow.
modification.
Nay, what is this modification?
My lord, item 101.
Modification.
If there is a judgment, the trial court will take care of that judgment. Why should I write the judgment according to your wishes? But this kind of application, please don't file.
My lord, 106.
If there is a Supreme Court judgment, you will have to show it to the High Court.
Taking the coactive person, your lordship has passed that observation, that line.
No. Observations are not modified. No, I will not entertain.
Your lordship, my lord, the coactive person, similar case. Your lordship
maybe similar case. You show that to the trial court. This kind of
my lord, item
you are creating burden on the court. That's all. Nothing else. Because the court is a bit lenient, that doesn't mean that you will keep on moving.
Lordship, all matters will be coming tomorrow. Lordship.
Yes,
all the matters.
My lord, 106, my lord.
Where whoever wants adjournment, tell.
My lord,
sorry,
my lord,
the item 127. I mentioned 126, 127, my lord.
127.
127.
My lord, 106.
After vacation, interview to continue, my lord.
127 already somebody mentioned.
127 already somebody mentioned. Interview to continue, my lord.
My lord, 126 tomorrow, my lord.
I said, if you are seeking adjournment, tell me. Otherwise, all the matter will come up tomorrow.
My lord, 106. Pray for an adjournment.
106.
Interim order to continue.
My lord, one is for the other side. And this will be again a racket. You know, you have to see interim orders have taken into behind the makeup for the other side. They'll take adjournment. Then applications will be moved. Be careful about it.
There are
Bring the other side.
number 136.
Bring the other side. No question of adjournment. 106, no, tomorrow. Next. Wherever there is an interim order, both the side has to be there.
My lord, item number 136.
Next.
83.
Yes. Adjournment. Interim order is there. No problem.
My lord, item number 136.
Yes, sir.
83. Yes.
Item 81 modification. My opposite party friend is also present.
Yes, 81.
81.
We'll take it up.
My lord. So, my lord, 81, my lord. Matter was. Matter was. So, my lord, matter was settled.
1 minute.
And affidavit was filed much earlier in the year 2023. My lord, and there was a direction that all the parties are remain present.
No, I see.
That
1 minute. When settlement matters are coming, I give dictation in the open court.
Yes, ma'am.
And I think my voice is reachable to you every time.
Yes, ma'am.
When I say all the petitioners and opposite party number 2 and 3 are present in the court, being identified by their respective counsel. Yes. Why have you agreed to that?
That correct. I'm submitting. My associate was there, but I was in another court. In Mallet, all three persons they are present and duly identified their identification. Petition number 4, he inadvertently he could not hear matter. Your lordship is asking directing all the petitioners present. That is whole difficulty, Mallet. That is
don't simplify all these things.
That is my
because of your this thing,
Mallet.
And I started doubting everybody now.
My junior associate, he unable to understand. 3 जनों identify करी देला order time. Again nothing mu dekhili order.
And many times what happens? The Aadhaar cards, self-attested Aadhaar cards, they don't give and they run.
What I mean, this so for the other accused is concerned, he is while affidavit was filed, he was present and so an affidavit. But on the date when the case is posted,
I will
on that day
see. I will quash the who all are they?
All are present. No. 1, 2.
You bring 4. All of them now.
1 or 4. 1, 2.
I'll recall this order.
No, 1, 2, 4 were present.
I'll recall this order. You bring all of
No.
them.
Maladu, all are present. All 1, 2, 4. Petition number 3 is in custody.
How do I know where 3 of them?
They were duly identified. 3 were there. 1, 2, 3 were present. Duly identified.
How do I know 1 was present or not?
Pardon?
How do I know 1 is 1?
There Aadhaar card duly identified. 4 nathila.
4 Aadhaar card.
Yeah, 3. Petitioner 3 or nathila.
Aadhaar card of
Samastakar 1,
3
1, 2 or 4.
81.
This is completely,
No,
you
not,
know,
certainly not.
unacceptable.
Certainly not, my lord. And one, two,
Because of
petitioner, my lord.
Because of conduct of one counsel, I have to doubt everyone.
No, it is nothing to be doubt, my lord. Immediately.
What nothing to doubt? Somebody is in custody and you are telling he is appearing.
Why he has made as a party when he was in
How
custody?
can you say he was in?
Where is your wakalatnama? Let me see first. Where is your wakalatnama? Whether you got it from the.
My lord, my wakalatnama is 21/8/2021 ସେତେବେଳେ ବାହାରେ ଥିଲା affidavit file କରୁଥିଲା କଣ କହୁଛନ୍ତି ଆପଣ
କାଇଁ
wakalatnama ଟା ଦେଖନ୍ତୁ wakalatnama
ଯୋଉ ଦିନ କେସ୍ ପ୍ଲେକବଲା ସେଦିନ ନଥିଲା
ସେଇ ଦିନ ନଥିଲା ସେ ଆଉ ଗୋଟେ 87 କଷ୍ଟଡି ରହି ଯାଇଛି
କଷ୍ଟଡି କେବେ ଗଲା
ଦେଖନ୍ତୁ wakalatnama ଦିଅନ୍ତୁ affidavit
କେବେ କଷ୍ଟଡି ଦେଖ
ସେ କଷ୍ଟଡିରେ ଡିସେମ୍ବର ମୁଁ ଲେଖିଛି ଡିସେମ୍ବର ମାସରେ ସେ ଯାଇଛି ଭିତରକୁ କଷ୍ଟଡିରେ ଆଉ ଗୋଟେ କେସରେ ସେ ଏ କେସରେ ନୁହଁ ଏ କେସରେ ଆଜ୍ଞା 3 ଜଣଙ୍କର ଫାଇଲ କଲେ ଆମେ ଆଧାର କାର୍ଡ affidavit ଟା ଫାଇଲ ହେଲା ଭୁଲ ହେଇଗଲା ଯେ 3-4 ଜଣଙ୍କର wakalatnama ଫାଇଲ ହେଲା
ये मर्डर केस अछि गोटे मर्डर 302 अछि
387 केस रे डिसेंबर
और
मास
अनदर 302 केस पेंडिंग अछि स्कैनर अछि
से केस रे
लॉर्डशिप में बेटर माय लॉर्ड दे recall the order my lord once again they will appear
face order
तार छाड़ के मते करना
3 जनकर आधार कार्ड फाइल करलु duly identified and by the time when filed my lord 4 all were they are all filed thereafter he arrested in December in the month of December and connected another
all total my lord more 6 persons there my lord 6 out of them 4 persons appear passing against 4 persons
FIR against 1 and others 6 others 4 were petitioners were there they were there they filed an anticipated bail thereafter they all the 4
Investigation is going on.
My lord,
there are 6 accused persons.
More than 6 my lord.
See the earlier order affidavit was filed my lord and the opposite party they swear an affidavit they came and they file affidavit on 24/8/2020.
What was the offense? What was the
307 my lord.
307 and only this I have specifically avoided in my petition
and arms act 25/27 arms act also there my lord.
He is in custody in connection with another case PS case number mu dehi mention karichi PS case number mu mention karichi 316 of 2023 is not in custody a relation re case re no
1% custody
रे बिलोंग छड़ी बाकी पास कर लूंगा
जेतले फाइल करथिला से कोन कस्टडी थिला
पासिंग दिन नथिला ना
सेई दिन नथिला जो दिन सेई दिन पिटिशन नंबर 4 was not there 3 was not there.
It is very easy to simplify
the date my lord the case was quashed he was in custody my lord how can they got the case against him
मने जने लोक भीतर वाले जो केस टा क्वास से केस कोन करछि
yes present here
that is
because not present here how can his case
was our informant is swear affidavit earlier जेतले अगस्त मास रे affidavit हला
sir it's a particular date to have better present otherwise happen case informant injured interested to pass
informant injured present. Let it come tomorrow. I'll recall this entire thing. I'll recall this entire thing and
he was not present. How can his case will pass?
This is unheard of. This is unheard of. See, this kind of thing only deteriorate the confidence of the court.
It is nothing to be malat. It's certainly malat. It's a 3 persons they were present. Malat, he is in custody. Petition number 3 is in custody on the date when the case posted. Malat,
will you not inform me?
That is. Petition number 3 was not.
Why have you played this game?
Nothing to be played, Malat. Then this code, Malat.
You should have informed me that this.
Yes.
That is the whole gamut.
Malat, this petition number 3 only he is.
That's the whole gamut. You can't be excused for this.
He is in custody in connection with another PS.
Why have you not intimated to me?
Malat,
you are getting a FIR quashed, a person is there in the custody, and you will not intimate to the court. And I am giving a dictation in the open court that all the accused persons are present in the court.
Probably that is the miscommunication that the
what miscommunication?
Kintu 3 jano karo affidavit.
It should be fair enough to tell the court
that is
unfortunately
but that is the my associate was there. He was unable to Malat follow your lordship's order.
When it comes to your any order favorable to you, it is.
But certainly, my lord, 3 persons they present their first one File appears there, Aadhaar card, everything is there.
You, you move an application.
Tomorrow,
From prosecution side, you move an application.
yes. Tomorrow.
No, they will move an application. Day after tomorrow, you move an application, I'll recall everything.
Yes.
And with a heavy cost of 50,000 rupees.
Mallet, I have file, mallet, everything, mallet.
You move up.
Yes.